soon to begin trial. Were there options that you had in terms of going to trial, taking a plea, or asking for a continuance?
Again, let me answer it this way. I'm not trying to be difficult, but an explanation. Legally, yes, we had options. We could go to trial or we could take a plea. Those things all in the very mundane, simplistic way, yes. But then as a practical way, my client didn't have the resources where he could hire me to conduct a year-plus trial. So those resources weren't there. So he also expressed other concerns he had unrelated to the trial. So you'd have to ask him as to what was going through his mind. But there are a lot of different factors that go into that. It's just not a simple yes, no. But yes, did we have different legal options he could choose? Yes. But why he made the choices he made, that's something you'd have to ask Mr. Sledge.
All right. And is it safe to say in here during the time that questions of those sorts were put upon Mr. Sledge?
Yes.
All right. And when you spoke about your client not having the resources to conduct a year-plus trial, did you ask to withdraw from the case at that point?
I did not. Ultimately, whether or not I would ask to withdraw and remove myself so he could either try to get appointed counsel or get new counsel, that would come after he makes a decision of what choice does he make among his different choices. Because he chose to go forward with the plea, then we never reach the issue of that.
And did you ask for a continuance at that point?
We did not. Well, I don't believe we did. However, I think I had been fully cleared to conduct trials, but I just want to say it might have been, it was right around that time frame. In fact, I think I had just finished a jury trial. So I think I was already cleared. So no, let me go back. We did not ask for a continuance.
And did you convey to the state certain things that your client simply could not agree to as it relates to some versions of iterations of plea agreement?
Yes, we.
Without talking about what they were?
Understood.
Okay.
What I'm saying is we definitely discussed different things that based on where my client's position was, where the state's position was, some things we were able to work out as demonstrated in the different iterations. And then there were some things we could not.
And Mr. Wright, my question is only, were there things that your client insisted or that you insisted on behalf of your client that the state change in its final form? Were there things? I don't mind any explanation.
I'm going to say yes, and here's the explanation. Almost all the things we asked manifested itself in iteration number 3. That was the version before version 4, which is the one that ultimately got executed. So when we were looking at version 3, we saw everything and we're good to go. Version 4 introduced item number 8, which was not what he wanted.
And is version number 3 the one that is marked State's Exhibit 456 Yankee? And then 1AS. 1AS.
Yeah. Personnel. No, this is not. When I'm referring to version number 3.
Would you do me a favor? I'm gonna give you all of the ones you just looked at.
Okay.
And would you identify by
Exhibit number.
exhibit number, which one you're referring to as version number 3? I'm gonna remove 456.
Your Honor, excuse me. Before the witness answers that question, do you mind if Mr. Shaw and I step and take a look at the exhibits? We're just not sure that we have.
Sure, that's fine.
Which one would the court like for me to give to, we look to you? Your Honor, may I please remove them from Mr. Wright's possession? Let them confirm that these are the ones that they were given yesterday.
Yes, and then give them back, yes.
Thank you.
Okay.
And if they have the ones.
I think it's more which one is which.
Okay, I did name them on the.
I know, but
Your Honor,
yes.
excuse me, I appreciate that it's early in the day, but could we just have 5 minutes?
Yes, let's take our morning recess while we do this.
Thank you.
Good idea.
I think it's 4:55. These are my.
Oh, those are yours?
Yeah.
Okay. Hey, Your Honor, just so that the records are clear, if anyone from counsel from the defense could just bring the ones that they had up from yesterday, they can compare it, because I gave them numbers.
If they want to do that, sure, they can do that. I mean, I think these are the things that were originally sent over as electronic copies, and that maybe, and they were like a file within a file kind of thing. So that's probably what the complication is.
And
Yes, you may.
Your Honor?
Yeah, and we're going to take a, yes.
I was going to, because they're going through the documents, and I shared with counsel for the state when she came up, the document I believe I was looking for is 455 Yankee.
Okay.
But I'll confirm it when I get them back. But that's the one that I think is the one that I'm looking for.
Okay, well, you'll get them back and we'll do that in front of the jury.
Yes, Judge.
I mean, you can certainly look through them, not in front of the jury, but we'll confirm whichever one it is once we've got the jury back. Okay, so we'll take like 15 minutes so that y'all can take a look and everybody who needs to can use the restroom. Yes, sir.
Another issue that one of the lawyers indicated that they were going to be speaking about.
May I ask if it pertains to these documents in this witness or something?
I think it, up at the bench, I think it was not these documents necessarily. Oh, yes, it was. Yeah. It should be somewhere within one of those documents. So are you going to tender those for admission, or are you just going to have the witness talk about them?
At this point, not before I do the necessary actions. I'm not going to tender anything. I'm going to ask him about these things right now. And as I said, I will not tender anything until I redact.
Okay, but I think there's an issue with regard to what ought to be redacted.
So we could, I don't mind.
Why don't y'all just talk? And then if y'all come to agreement, great. If not, then we'll check it up. So, 10:30, I'll plan to come back.
Okay.
Okay.
direction on a couple of them.
Okay.
So as it relates, Your Honor, to what we discussed at the bench regarding State's Exhibit 460. And State's 460 is the paper copy of Mr. Sledge's email, Mr.
Mhm.
Rice emails.
Right.
On the next to the last, I'm sorry, the last page of State's
Yeah.
460. And Mr. Sharp is standing next to me, so if he has that, he could pull it up and confirm that I'm getting this part right. There was an issue at, you wanna look at mine?
Well, I don't, no. Continue, I was trying to interrupt. I don't have 460 printed out, so I'm just gonna watch on.
Okay,
Okay, go ahead.
Okay, so at the bench, there was an issue, number 4, does the court have its copy?
I do.
All right, so there was no problem from counsel for the defense that actually voiced any concern about the first full sentence.
Uh-huh.
The concern voiced by Mr. Adams, I think echoed by Mr. Sharp, was the second full sentence. And then they wanted to keep in the third and the fourth sentence. What I told them was that sentence, that number 4 was made in response to the email, and you can tell that from the time and date that it was sent. That was sent in response to the email that was sent to Mr. Wright, and that was dated December 27, 2022 at 5:06 p.m., which was State's 452 Yankee. The email that contains, and it may have been that we did include it twice. So Mr. Wright sent us an email on December 27, 2022 at 8:43 p.m. in response to the email that I sent to him that was subject Sledge Agreement Updated. And in that email, Mr. Wright enumerated 1 through 8 regarding factual acknowledgements. 452 is the email he was responding to that the state has sent. And number 4,
Yeah.
yes. And so to the extent that the counsel for the defendants have all indicated during the break that they would like redacted from any prior iteration, anything that was not included on the final State's 1AS, the final plea agreement,
Uh-huh.
to the extent that number 4 on State's 452 Yankee gives context to that number 4 on State's 460, it would be necessary to be included to show that that was something that the state put on there that it believed to be true, that Mr. Sledge said no, and this was his response through his attorney.
Okay, so I'm confused now. On the different iterations that lead up to the final agreement, I understand that one of them is this number 4 that the state was proposing that he say
That he was saying.
that he, Sledge, had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that
In response,
the defense wants redacted the earlier version of number 4?
yes.
You're
Yes.
okay. I think we're going way down a rabbit hole here. The state seems to me, we don't need anything redacted if it's not being admitted into evidence.
Well, I think it is going to be admitted or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant. I mean, if these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual because it's not in fact what he ended up agreeing to.
I agree.
Yes.
Well, can I just?
Yeah.
Some things.
Okay.
Okay. First of all, I agree that Mr. Sledge said that. I also know that Mr. Wright and actually Mr. Sledge acknowledged that some things were changed, some things were not changed. So
Mhm.
no one is claiming that nothing was changed. Okay, that's first. But secondly, I want Your Honor to understand, and I sought clarity from the state because I don't work for the state. I was not communicating with Mr. Sledge back then. These initial factual acknowledgements were in no way based on anything Mr. Sledge ever said to the state. The state came up with these factual acknowledgements from a review of the discovery
Mm-hmm.
and proposed these. So
Right.
the genesis of these is purely divorced from anything Mr. Sledge stated, okay? It's not, there's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgements, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state from looking at the discovery.
Okay.
So I would ask if we're gonna let in basically I'm gonna say incorrect information that Mr. Sledge has never agreed to. And we're gonna expose the jury to this. I think we need to be a little stronger with the instructions and say, these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
I get your point. I get your point. And y'all, this is why I had us come a half an hour early is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, et cetera. But, so Ms. Love, are you not in agreement with redacting things that didn't ultimately come into the final agreement?
Correct, for the reasons that the court earlier alluded to, and also.
All right, and you do realize that some of what might come in like this, if the version of number 4 comes in that is a proposal that YSL Associates were planning to murder Donovan Thomas Jr., that there are concerns with putting that type thing before the jury.
Well, I do want to hear the court. I do want to understand fully the concerns that all of them that exist. And ordinarily, I would simply leave it at this. Yes, I know there are concerns, but in as much as Mr. Sharp has indicated that, well, his version of reality, mine differs slightly, and I would not go so far as to characterize.
I'm not going to give an instruction that says this is not based on anything. Okay.
Well, can I just respond to that though? But if you're not gonna give an instruction, Judge.
I am going to give an
I
instruction
understand, but
if this even comes in.
this is the problem. If this comes in, I think the jury would want to know, well, where did the starting point come from? And the only way we could bring it to the jury, because I didn't really know until this morning, to be honest, where the starting point was. It's always been a question of mine, how did these even get the first version? Where did it come from? The only way we could really bring that to the jury is to call the drafter of the acknowledgements to the stand, who I assume is Ms. Love, and ask, well, these acknowledgements that you drafted, When did you draft them? Was it based on anything Mr. Sledge said, or was it based on the discovery? Because, and I'm being forthright here as an officer of the court, Your Honor. I've never been a prosecutor, but I was under the assumption that there was something that Mr. Sledge said that led to the first statements, and then it was like an editing process. But the first version was not based on anything Mr. Sledge said. And that's important, because the jury has to determine, okay, did the state just come up with these? Did Mr. Sledge say certain things and he's backing out of them now? And if we don't make it clear to them that Mr. Sledge was not the genesis of even the first version, I think that question becomes unanswered, and the only way other than an instruction would be to call Ms. Love to the
All right, Ms. Love, what's your response to that?
Your Honor, one, again, the idea that
All
this,
right, I don't need like
I'm
a
not trying to go-
full-blown
my response,
rehash of everything. What is your, let me re-ask, what do you propose?
I propose that the court instruct the jury that it is to take as fact no information contained in any iteration of the plea agreement unless that assertion or that factual acknowledgement is in the final version to which Mr. Sledge.
Let me ask you this. Would you be able to get essentially the same information before the jury? And I believe the information you want before the jury is that very material things about the factual acknowledgements were changed at the request of Mr. Sledge and Mr. Wright. Is that essentially the point you want to make?
Blandly, yes. I think that I would rather ask Mr. Wright, did the state ask, because essentially that's what we're doing, because we couldn't sit down with him. Did the state ask your client if he had personal knowledge that the murder of Donovan Thomas was pre-planned by YSL members? Did we ask him that? And did, through you, your client tell us no? Did he say no? He
So
doesn't
what
believe that the shooting was,
he says he did not know.
right.
He thinks it was not planned, but more impromptu, or at least very short or little planning.
Right. So we don't need all of that.
What's his basis for knowing that? I mean, that's part of their problem.
That it was impromptu with little planning. Well, because he was at the house with, if we're talking state's theory, because Mr. Sledge still has not met with us, but if we're talking what we believe is that everybody was talking about it. They were at the house. We have more than one witness who says at Defendant Williams' condo, they met up. And
After
it was
the fact.
Yes, after the fact. And they talked about it. They talked about catching.
Okay, they could have talked about it and it never come out whether it was planned or not.
And based on the conversations, this is what I have gathered, based on the conversations that Mr. Sledge was privy to, his understanding was that it was not pre-planned. And that is the reason when he says what he does, that he says it. So we're not trying to get into what he thinks. We'd be sufficient with, did we ask him that? Did he tell us no? Did we at first have something
Okay,
to
so
that?
I think that's a
effect?
lot safer way to go about it is, did we ask him that and did he say no?
And did he
And leave it at that and not follow up on, here's what he thought instead.
I
Okay,
completely agree. But
okay,
the
well,
part
that's
that
not
I
what you
think
said a
is,
minute ago.
okay,
So
the part that
go ahead.
the part that I'm concerned about and would like to also put before the jury was, and did we include that question as part of the factual acknowledgments initially? Is that something that he absolutely said no
Okay.
and refused to acknowledge and had insisted that we change?
All right, so it seems like if y'all, the defense wants in portions of number 4, that maybe the sentence at issue could read, he thinks shooting Peanut was not planned, and then redact the remainder of it. Because that shows that he is saying, no, what the state is asserting is not true to my knowledge or belief.
And if the court lets me leave Mr. Wright, I can say, did he tell us? No. Did we
Okay.
ask him, did he have personal knowledge, was pre-planned? Did he tell us?
Okay,
No.
but if we're talking about how to redact 460Y if you
Okay, I see.
tender it,
Yeah.
then that would be, I think, a much safer redaction.
So taking out everything except he thinks the shooting was not
No,
planned?
no,
or
taking out, leaving in everything except, but more impromptu or at least very short or little planning. Mr. Sharp.
Well, I just have concerns with the state. Here's, the state can have their theories. Mr. Sledge on the stand has said, no one talked about the murder, okay? I mean, they talked
Right.
about
At the
Mr.
coffee
Toneman,
shop.
yeah,
Oh.
they talked about Mr. Thomas had passed, but no one was saying this is what happened. There was
Right.
no discussion. So when you ask someone, if Mr. Steele asked me, hey, was that murder pre-planned? And I say no, then it insinuates, it gives the impression that I know about the murder. I have some information about the murder.
Yeah,
And that's my problem, is just saying that in a vacuum.
okay. So how about, I mean, the beginning of what he says is really the answer. He said he did not know, and the rest of it is elaboration.
And Judge, the portion that was, let's see. Okay, so based on what Mr. Wright wrote back to me, we included a line that was not initially included in the previous iteration that I think is 452Y.
Okay.
And I think that line is number 8. And we drew the same exact conclusion and I'm sorry, number 8 of 1AS. Number 8 of the document that did get admitted, which is that defendant personally knows that one or more YSL associates committed the murder on behalf of YSL. So based on the response that we got from Mr. Wright, from Mr. Sledge, that was what we concluded too. And that is why we put in here number 8, which is different. And it may not be in the prior iterations, but as we went back and forth,
Okay. So, I mean,
Judge.
I think that it would be safer in terms of what gets put before the jury if you do this through question and answer with Mr. Wright.
All right.
Would you be, I mean, you let me know whether you're going to insist on tendering, but.
I'm certainly not going to do anything the court says don't do.
Well, I'm not telling anybody how to
And I know,
try your case. That's not my job to do.
understood. I'm not going to tender it before the lunchtime hour, at which point, if there is an issue that we need to hash out, or I need to say,
Okay.
but at this point, I am very much intending to handle this verbally with
Okay.
Mr. Wright on the stand,
All
because
right,
I
and
think
is
it's
it-
something that I can do clean.
All right. Is that going to be true with regard to also not tendering the different versions, just talking about them?
Right now, yes.
Okay. Yes, sir.
Let me just point out that in regard, just very briefly, because I don't want to, go back over everything we just discussed, but number 8, that's referenced by.
You're going to have to give me some
in-
number 8 on which.
1AS, the final iteration.
All right. I don't even have that in front of me, but I know it is. I just, there's a lot of evidence in this
It
case.
is-
And I only have 2 screens. So
Is the
give me a
one-
second. to
But I
get
can
it.
orient the court if it helps.
If you'll just give me a second. Okay, that works too.
It's 444.
All right. Go ahead.
So 1AS, section 8
Yes.
is the portion that Ms. Love just referred to, where she says that we made changes to the document based on what Mr. Wright said back to us. And so we came up with 8.
Right.
Defendant personally knows. Well, if the court recalls, that is what they asked Mr. Sledge about when he was on the stand, and he specifically disavowed it. He said, no, that's not accurate. That's not true. And so if we go back to what we talked about earlier this morning at the bench, my simple request was just that, and I think we may have reached there, I kind of got lost a second ago, is that in regards to them sending this iteration and Mr. Wright sending back the response that shows up in number 4, all right, number 4, where he says, he said he did not know. That's the answer to the question. And I think that's where the court ended up, that's the only.
No, where the court ended up, and we talked about that yesterday, was the he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was he doesn't know that.
Right, but what we discussed at the bench earlier, and the reason we asked for this portion, for that sentence, the sentences reads, he thinks shooting Peanut was not planned, but more impromptu, or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that.
Yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
But maybe I'm just not understanding, because I took the court's previous ruling and I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out, or agreed, and we thought that that part was not going to be read to the jury or presented to the jury.
I don't think that part has changed.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
What he had said.
Right.
Yeah, right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Ms. Love is going to somehow get from whatever it was he said, hang on.
Number 4, Ms. Wright's email.
If she thinks she can get from, it was pre-planned, no, he didn't know that, he couldn't say that, to somehow that answer being the basis for putting in, he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Ms. Love, you're the one that's putting them all into issue right now.
I'm putting them into issue to impeach what Mr. Sledge said regarding his regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with. And they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So how you deal with that is up to you, but
since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury. I am talking about this idea that the state.
Well, the easiest way to do that is, so what was it that you wanted changed that didn't get changed?
Right.
And then why is it that well, that would be speculative, but I just said I wasn't going to tell y'all how to try your case, but okay. So we are not at this point going to be admitting any of these.
We're not
just going to be
tendering them to-
discussing them with him.
At this point,
All
correct.
right, yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Shart said, would you also go through an analysis of confrontation clause? Because the statement now comes from a party opponent and it's used for litigation. It is a clear, to me, bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright.
Well,
Okay.
okay, sorry, I thought you were
No, no.
finished.
Second part, and I apologize, I'll be very brief. Second part is a 403 analysis. You know, it's like saying, Ms. Love saying to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence or in the presence of Mr. Harvey? And then Mr. Adams responds, no. You know, that's really bad for a jury. That is really bad. And that's really what's going on here. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity to Mr. Sledge through his counsel to make amendments? Answer, yes or no.
Mhm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness because of the confrontation clause, and I think it's very prejudicial under 403.
Okay.
Your Honor, we've had the witness on the stand that made the statements, that signed them. We've inquired of him. He's
Yeah, I think
made
that
some.
does take care of the confrontation clause issue. And with regard to 403, I mean, I agree. We've spent the whole morning on this, and let's target the questions to get to the cogent issue, which is, were they able to make material alterations upon request?
Yes.
All right.
Yes, Judge.
Okay. So we ready to get the witness back in and the jury back in? Yes.
It is cold in here.
I'm sorry.
I mean,
Mainly.
I have a heater that he can use if he's cold,
oh no, I mean,
so we don't turn it down.
I'll soldier through it. I'm just,
I can use my heater.
I was just wondering, is it me? Or-
No, it's cold to almost
good.
everybody except for the judge and the deputies.
And Ms.
And a couple of the jurors who are fanning themselves because you're too hot. And,
She was fine.
but yes, it's not an ideal temperature for everybody.
No, I'm good. Thank you though. Yeah. Observer present, counsel.
Thank you. Thank you, Judge.
Sorry, I adjust the door a little bit.
Mr. Wright, I'm going to put in front of you states 1A once more. And I'm also going to put in front of you states 452, Yankee. Are you able to discern, are you able to tell whether, and I'm putting in front of you states 460, Yankee, which has been admitted as evidence.
Okay.
And are you able to determine if 460 Yankee was sent in response to 452?
I don't know that that's been admitted. 450 was
452
admitted.
hasn't, I haven't,
No, I don't, did you say 460 was admitted?
I believe, yes, 460 was.
And it hasn't.
It hasn't?
Only 450.
Okay. Your Honor, the state. Because of, okay. Without reading anything from 460, thank you, Judge. Without reading anything from 460, are you able to tell if 460, the last 2 pages, were sent in response to 452, Yankee?
I do not believe so.
Is there one or anything that you have a record of that occurred between when 452 Yankee was sent to you and 460 Yankee was sent from you?
Okay.
Without saying what it is, because we haven't entered anything as
Okay.
evidence, do you have a record of any correspondence that occurred in the middle?
The record would be in reviewing my emails
Uh-huh,
and without going into the contents,
uh-huh.
there's what I saw and had on the 27th of December, and then what we were interfacing back and forth on the 28th when we were in court.
Do you, looking at 452 Yankee, is 452 Yankee, did you say earlier that that accurately reflects an email sent to you on December 27th?
I did. But I'm looking and thinking there were at least 4 versions, but there might have actually been a little bit more. But when I'm looking at what I thought was the first version, which is what I thought my response was to, it looks like this may have been an updated first version, meaning I'm just seeing some slight differences. That's why I'm hesitant to just say, yes, that this is it. I can't say, is this iteration that was in that process of getting us to the end? Yes.
All right, are you able to say if there is any material change from the number 1 under the factual acknowledgement section from 452 to whatever version you're looking at that you think you might have been responding to?
To jump
Just number 1 under factual acknowledgements, number 1.
okay. Number one's are,
Don't
one
say
is,
what it is.
one is the same.
Okay, my only question relates to number 1.
Okay.
All right, and so as it relates to number 1 on the factual acknowledgements that you were responding to when you said 460Y,
Mm-hmm.
Is that number one the same as in 452Y?
Yes,
Is that the same in the document that has been admitted as 1AS in a prior hearing?
let me just to. Yes,
And is that the same as number one on State's Exhibit 444Y?
All right, we already established that 1AS and 444Y are the same document, so we don't need to ask that question for all of them.
All right. Did you convey in 460 Yankee that I have in my hand that you did have? Did you convey in an email to the state on December 27, 2022 at 8:43 p.m. that is a part of 460 Yankee? Did you convey changes that needed to be made to the plea agreement in the form that you were looking at, whichever one it is?
yes,
Were those changes reflected in the document that is 1AS? And I don't need you to read it
yeah,
out.
no, I was gonna say, all the changes were ultimately incorporated. The only issue with the document 1AS is number 8.
Okay, so are there any changes that you saw need to request that you do not see reflected in 1AS? And they don't have to just be in States 460. Are there any changes in 1AS Are there any changes that you asked to be made that aren't made in 1AS? Material changes.
What I'll do is,
Number by number on,
first with number 3, we indicated,
wait, you cannot say
Okay.
what's in there.
Okay.
I just need you to roll it.
no, number 3,
I don't know of any ruling that the court has made that says he can't indicate what the change that he requested being made. And that's what I understand that he was about to explain.
Your Honor, it's going to get into,
So the question was, are there any changes that were requested to 1AS that were not made? So he's entitled to answer that question.
okay?
And if you want a full answer, we don't know what he's going to say. So
Yes, is
it's the final
So
document
that
that got
question-
signed.
right.
So given all of our discussions, Ms. Love was trying to be careful about careful. So if you're objecting to,
I'll withdraw my objection.
okay.
So, Mr. Wright, would you just follow along with me and let's do this exercise using only the numbers under the factual acknowledgement section in document 1AS? May we do that?
yes,
All right. So,
Can I make a suggestion? 1AS is, or a version of it, 444Y is in evidence. Would it be beneficial to display it?
Your Honor, my understanding is it's not in evidence.
444Y is, and 1AS is the same document.
so
Is it not?
I don't believe it is. And
Let me take a look.
Please do.
And Your Honor, if we can approach, I can explain, we already discussed this at the bench.
Okay, no, you're right. I remember. Okay, never mind.
Just same numbers.
Correct. If we could just use the numbers,
I would say,
and I'm going to address them one, is that okay?
sure.
All right. So, was there a material change as it relates to number 1 of 1AS that you requested that was not reflected in number 1 of 1AS?
No,
Is there a material change to number 2 of 1AS under factual acknowledgements
no,
that you requested that was not made?
no,
Is there a material change to number 3 of states 1AS under factual acknowledgements that you requested but was not made?
3, yes.
So we'll put that down. And we'll come back to it.
Mhm.
Was there a material change to number 4 in states 1AS that you requested that was not made?
No,
Was there a material change to number 5 in states 1AS under factual acknowledgements that you requested that was not made?
No.
That Mr. Sledge requested that was not made?
no,
Was there a material change to number 6 of State's Exhibit 1AS under factual acknowledgements that Mr. Sledge requested through you that was not made?
no,
Was there a material change to number 7 under factual acknowledgements as reflected in States 1AS that Mr. Sledge requested that were not reflected in number 7 on 1AS?
no.
Can you just say same question for number 7, same question for number 8?
Okay.
Okay.
Same question for number 8, and if I think number 8
Yes.
wasn't on a prior,
And yes, but, and again, it wasn't on a prior edition, but it,
was on the
Added to
last
this one.
edition.
so, but
So
the
I can't,
subject matter was one of the things we said.
okay. So, Your Honor, I can't ask the same question, okay. All right. Number 9, was there a material change regarding number 9 that was requested by Mr. Sledge through you that is not reflected in number 9 under factual acknowledgements of states 1AS?
No,
Is there a material change to number 10 on states 1AS under factual acknowledgements requested by Mr. Sledge that was not made on the final document?
no,
Same question for number 11.
no,
Same question for number 12.
no,
Same question for number 13.
no,
Same question for number 14.
no,
Number 15, same question.
no,
Number 16, same question.
no.
All right. As to the sentencing acknowledgements that are reflected in states 1AS under section 5, did you review those? Are you comfortable telling the jury whether or not you went over those sentencing acknowledgements with your client? Just yes or no before you explain anything.
I would have went over the entire agreement, including that section, yes.
Okay. Did you allow your client an opportunity to ask any questions that he needed to ask?
Yes,
Did you restrict his ability to ask you questions?
no,
Based on your knowledge of over 15 years of interacting with your client, did your client appear comfortable asking you anything he wanted to ask you?
yes,
Did you answer your client's questions as thoroughly as you could possibly do in your capacity as his attorney?
Yes,
Did you answer them in a way that based on your 15-year knowledge of him, you believed he fully understood?
I hesitate. My answer would be yes, but again, I'm not a mind reader. So other than perceiving his responses to me and that he seemed comfortable, I can't purport to say what all is going through his mind.
I didn't ask you that.
Yeah.
I appreciate your response. I appreciate your clarification. So I asked the question I did for a reason. Based on your 15 years of knowing him,
Mhm.
did he give you any indication that he did not understand any one or more of the provisions under number 5 sentencing acknowledgements, which are in 1AS?
No,
And when you said yesterday that you had represented Mr. Sledge in 2 cases over the last 15 years that were felonies and 1 that was a misdemeanor, would you explain like what it is, how you're able to determine when he doesn't understand something as it relates to a plea, and how you're able to determine when he does understand something? What does he do when he doesn't understand something?
well,
Your Honor, I'm going. Same objection.
Sustained.
How do you decide that something needs more clarification when you're interacting with Mr. Sledge?
with Mr. Sledge or any other client,
I just need Mr. Sledge.
well, the point is, I'm going to state what's, I guess, in front of us in terms of what any particular paper is going to say. Make sure that it appears to me that he understands it. Give him an opportunity to ask any questions if he doesn't understand it. And then in a document such as this, where he's going to initial, that's just another way of him indicating that he has seen it. He's had an opportunity to discuss it with me, and he doesn't have any questions that we need to address to the court or follow up.
And do you pay attention to body language when you're asking him if he understands something?
Yes,
Do you pay attention to pauses or hesitations when he responds in order to determine if he just doesn't want to say it or if he really understands it?
I don't speculate. Didn't go that far.
Yes.
I'm trying to get a direct response so that I know how to proceed. But I understand your question, but I'm saying I generally am not going to try to surmise based on just body language. If there's something that creates a red flag for me, then I'm going to follow up with a question.
Your Honor, I want to ask a question that's going to harken back to something yesterday. It's going to sound not relevant. I ask the court's indulgence for a moment for me to ask this question. You remember yesterday when you were telling the jury that a particular question sounded like a hot topic, and I asked you, what did you see from me that made you think it was a hot topic?
Understood.
Okay, so when you're talking to your client, what do you look for to see or make you feel like he does understand something?
I'm listening.
Object. I believe that question has actually been asked and answered.
Sustained.
Are there nonverbal cues that you look for to see whether or not your client understands something?
I would say yes. I mean, I'm looking at their facial expression. Do they seem to be very clear on what we're discussing, what the topic is, what their response is? And, obviously if the client is very emotional, that's the more obvious. But I'm just trying to make sure, have you heard it? Do you understand it? And what is your answer? And then ultimately, we go from there.
Have there been instances during this plea or any other with Mr. Sledge where he's asked you the meaning of certain words that he did not understand?
I don't have a specific recollection of him asking about the definition of a word. However, anytime he had a question about the content of a statement or what that means, he did not hesitate to ask me.
Okay. Did you take care to explain what you would consider legalese or legal terms to Mr. Sledge that you thought he may have a problem understanding?
Anything that is of a legal effect, legal character, I'm going to make sure he understands in very plain terms, him or any client, what that means.
Did you go over each one of the 6 sentencing acknowledgements, both before and at the time that Mr. Sledge signed or initialed the 6 sentencing acknowledgements in States 1AS?
Yes,
And what about the last paragraph underneath that 6th sentencing acknowledgement? Did you go over that with him before and at the time that Mr. Sledge signed the document that is labeled 1AS?
yes.
Is there anything you haven't talked about that you now can think of that makes you feel in any way there was something he didn't understand?
Objection calls for speculation.
Sustained.
All right, let's go past that. Thank you, Judge. When you signed States 1AS, was it at the same time that Mr. Sledge put his signature above yours?
It would have been immediately after, yes.
All right. And on the same date that it was signed by the DA, by the assistant district attorney that is indicated?
Usually he'll sign it, I'll sign it, then I'll present it to you and then get your signature.
Okay. Was there any material addition that you asked to be included in State's Exhibit 1AS that the state refused to include?
There was no addition, no.
Okay.
Or rather, let me say it this way, no addition that we asked
Okay.
that was not included.
Okay. Was there something you requested be taken out of the plea agreement that is a part of States 1AS? And I stopped that question right there for a reason. Is there something you requested be taken out?
Yes.
And is it contained within a number?
Number 8,
Okay. And at what point did you request that number 8 be taken out?
even in the very beginning in my initial email, we were given an indication that he did not have information.
Wait a minute, you're getting into it. I'm asking you about a time frame, just the time frame, because of.
From the very beginning.
Okay.
That was one of the things that was an issue for us.
Was number 8 included in any previous iteration
I would have,
before states for? Based on your notes,
Mhm.
what iteration did the date and time that number 8 first appeared in,
well,
based on your notes? And without saying what number 8 is.
understand. And let me work my way backwards. I'm going to look through the earlier iterations, but I can tell you the one before this exhibit, which for my records was iteration number 3. It was not in there. So the subject matter of number 8 had been removed from earlier versions, was not present in iteration number 3, such that it appeared again in iteration 4.
And so would you tell me, or the jury rather, what iteration between states 450 and states 456. Let me put 452. And including states 452. What iteration of that agreement did number 8 first appear in? Just by date
Okay.
and time and exhibit number. If it's in there.
Okay. It was not in 451Y.
Do you understand the question I'm
Well,
asking?
no, I am. I'm sorry. I'm answering in a way where
So with
iteration by iteration, I'll be able to say if it appears at all. I do not believe it appeared in any prior iteration in that form. But I'm looking to just make sure the subject matter, if it did, I can answer your question and say it appeared in this.
if you find it, then point it out, but otherwise, just reach yourself.
Okay. Okay. In 452Y, number 4, the subject matter of that appears.
Okay.
It does not appear in 454Y.
Just if you see it.
It appears in 456Y,
Okay.
also number 8.
Okay.
And I had skipped over 455Y, but it does not appear in 455Y.
So as you read over and initialed 1AS with your client, I'll take these.
Yes.
Did you ever speak to the state about number 8? To the best of your recollection, did you request that number 8 be removed?
No, I did not. I have no recollection of seeing number 8. I understand my client initialed it because I can see his initial. I also understand it may have been enunciated by the state at the plea, but where we went from 455Y, where it was not in there, and then it was in there, I don't know how it got there or how we missed it, because neither my client or I appeared to have realized it was there and it came in.
Are you saying that you did not read this document before you all signed it?
No, we read it and signed it. I can't dispute that. But how that number, when that was something from the very beginning we were contesting, I can only say we missed it and it's in there.
All right. And when you say you were contesting it, how did you contest it? Without saying what you said, but how did you contest it?
Well, by telling the state that that information, that's the subject matter of that, is not something that he has knowledge of or information on. So I'm sort of hamstrung to answer your
Okay.
question.
All right, we'll come back. And so at the time that this document was being read into the record, were you paying attention?
I was paying attention, but I missed it. So apparently not good enough. Just as when I went over it with my client, which I did, I'm not saying I didn't, but that is something that to this, I mean, it sort of was a surprise of this trial for me, was that was in there, and how did we miss it?
And when you speak of that was a subject matter, beyond it being something you referenced in, you said you saw it in reference in 452 Yankee number 4, and you saw it in 456 Yankee as number 8, the final iteration. Is that fair? Did I get that right? Okay. Do you have notes, or do you have an email or a text message or anything that reflects, hey, 456 or number 8 on this document, not the final, but number 8, take it out?
To answer your question, going back to when this was happening, when we saw 455, it was not in there, and everything seemed consistent with what we had asked. When we were handed 456, I think we must have assumed, and I don't want to speak for Mr. Sledge,
Don't assume.
well, that 455 was what was being handed to us to execute. And we did not notice because, again, it's an addition. It's a completely different sort of addition, and it's in there. And again, I'm not disputing it is in there, but I can't explain to you how we missed what we thought we were signing, or what I thought we were signing was 455, not 456, with that additional number 8 embedded in the factual allegations. And I don't have an acceptable explanation as to how we missed it.
Okay, so looking at 455, and Your Honor, this is one of the last 3 questions that I have. Looking at 455, is 455 Yankee number 8 what you referred to when you said that you thought 455 Yankee was the last iteration?
Correct. And I'm not going to go into it, but the subject matter of number 8 in this is different than what number 8
All right.
in 456 is.
And so is 455 Yankee number 8 what you were trying to agree to?
Yes.
Okay. All right. And does 455 Yankee have 13? How many factual acknowledgements are in 455 Yankee?
15.
And are there 16 in State's Exhibit 1AS? Here you go.
Yes, there's 16 in 1AS.
And beyond was there anything in particular about number 8 on 1AS that you brought to the state's attention at any time before now?
In the very beginning when, without going into the subject matter,
You can give me just date and time if there's an email you're referring to.
on December 27th, the email at 8:43,
Uh-huh,
item 4
okay.
was related to the subject matter of item 8.
Did you respond specifically to item number 4? Did you respond specifically to item number 8 when you wrote item number 4?
Hold on one second. I'm looking for the iteration I had when we sent those responses.
Yes, sir.
It may be. If you could hand me, I guess, the first version or first updated version, then, because I think I've got my stuff intertwined now.
Okay.
But what I was going to say, because I was going to reference what the subject matter of number 4 is.
You can't do that.
Well, not out loud, but what I was going to say is, yes, it's the same subject matter.
And were you speaking specifically to a number 4 in a previous iteration when you wrote and responded to number 4?
Correct.
All right. Your Honor, thank you. I think that that's all that I have for the witness right now.
All right, cross-examination.
Your Honor, for the record, I'm just putting 1AS back with Ms.
All right,
Winfrey, and I'm taking back the ones that were not admitted.
thank you.
You're welcome. This is not. This is.
Okay. I think that's it.
No, you're all good. Good morning, Attorney Wright.
Good morning.
I believe we met briefly to introduce myself yesterday or the day before, but again, I'm Doug Weinstein and I am Diamante Kendrick's attorney.
Yes, sir.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
You do not.
Okay. We talked about proffer sessions and a proffer session, again, I believe you said, is when a defendant meets with the state, correct?
Correct.
So to avoid legalese, I'm just going to talk about meeting with the state instead of using that word proffer. Okay?
Yes, sir.
All right. So if there would have been a meeting between Mr. Sledge and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. Sledge and Attorney Love before December 27th?
No, not that I have any recollection of. And I was, I never want to give an incorrect answer. So I was cautious, but I don't believe we ever actually sat down for a proffer.
Was there a meeting between a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No.
Was there a meeting between Mr. Sledge and any member of the district, any attorney in the district attorney's office before the 27th of December?
Not that I'm aware of, no.
What about an investigator with the attorney's office?
No.
I have a slight objection just as to clarification because there, I'd ask that the meeting part based on other interactions, just vague. Was there any
The
meeting?
objection is vague.
Okay, let me clarify. When I've used the word meeting, what I mean is a proffer session. So to all of those questions, if I had used the word proffer session, were there proffer sessions?
I'm not aware of any proffer session that was ever conducted or even a more informal interview with anyone from the DA's office or law enforcement as it relates to this case.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgments, correct?
Yes.
So how in the world, to your knowledge, did the state come up with those factual acknowledgments for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to how the state did something or came up with something.
Overruled.
I believe the state was trying to surmise through its overall
Well,
investigation.
now, he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual problems.
So you don't know how the state put those words in your client's mouth?
I do.
As to the characterization of,
Sustained.
Okay. How many plea negotiations have you conducted in your career?
Definitely over 1,000, maybe 1 to 2 or 1 to 3,000 over 30 years.
Okay. And these plea negotiations are like any other negotiation that takes place between parties, correct?
Absolutely.
There are things that you want in the final agreement, right?
Yes.
They're the things the state wants in the final agreement, correct?
Yes.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
All right. Does anybody else have questions from the defense? for
Your Honor, I
this
have
witness?
a motion as to part of that, but I'll ask it at the time that we break.
Okay. Mr. Adams?
Attorney Wright, good morning, sir.
Good morning, sir.
Like Mr. Weinstein, you and I have known each other a long time, haven't we?
Yes, sir.
All right. Got a number of questions for you, and I want to break them down into specific parts, okay?
Okay.
And same ground rules. If you can't hear me, you don't understand the question, just ask me to repeat myself, clarify, whatever you need, and I'll probably have to do that.
Understood.
Let me kind of start where Mr. Weinstein left off. Proffer session. It's been a reference, which is a meeting between your side, you and your client, and the district attorney's office. Never happened. True?
Correct.
Objection, ask me.
Sustained.
All right. You did receive, as we've seen previously, that email with the proffer agreement attached. Is that right?
Objection, ask and answer.
I did.
Sustained.
You have never seen, never received, and there is no signed proffer agreement.
Objection, ask and
Anyway,
answer.
is there?
Sustained.
And your interest in representing Mr. Sledge would have been to try and gain whatever the best situation was for him. Isn't that true?
Objection, vague and relevance.
Overruled.
Absolutely. In anything, the best interest of my client, that is tantamount. That is the absolute goal. I want not just keep them home, not just some things you might think. I want the best possible solution for the case.
In this case, in representing Mr. Sledge, you indicated you'd known him for well over 15 years, true?
Yes,
And at the time that you came into this case, you were aware of the indictment and exactly what he was charged with in the indictment.
yes,
You knew that he was charged with one count of RICO, or violating the racketeering in the RICO Act.
yes,
You knew that he was charged in count 30 of the indictment with possession of a firearm by a convicted felon.
I did.
The count 30, the possession of a firearm by a convicted felon, is something that he was accused of. The allegation was that he committed that offense in December of 2021. Is that right?
Yes,
Right, and that was included in the overall indictment with the RICO count, true?
yes,
Having represented Mr. Sledge before, you knew not just him, but you knew his family as well.
yes,
You knew his mother.
yes,
And so when you were in court over the course of the last number of days, and you heard testimony and questions about him wanting to get home to his sick mother, is it in fact true that his mother was ill?
yes. I have personal knowledge that at the time we were going over this stuff, that was something he expressed and was stressed over.
That was a concern of his.
Yes,
You knew, and I want to kind of reference some dates. He was arrested somewhere in June, around June of 2022. Is that right?
I'm relying to some extent, but I'll say to the best of my knowledge, yes.
Well, you know that the case was indicted. The indictment was handed down in May of 2022.
Actually, that being the case, yes, he was arrested not long after.
Okay. You, and I don't want to delve too deeply into it, but you shared that at least in the early part of that, you were having some health concerns yourself.
Yes, and let me back up a little. The reason I paused on my answer was, remember, there was sort of an earlier part where he at some point had charges related to this. Those charges ultimately went away. Then much later on, there was an indictment and then an arrest. That's why I sort of paused, because that earlier date is not immediately known to me. But as to once this case was indicted, then the arrest, even though I was not back to my practice yet, I was aware of it and was sort of watching from the sidelines.
Okay. You were in court and heard when he was testifying about that previous matter you're referencing. In other words, his arrest and where he was charged with the murder of Donovan Thomas.
Correct.
And so at the time that you come into this in 2022, you have knowledge that detectives with the Atlanta Police Department had previously charged him with Donovan Thomas's murder and then ended up dismissing it or dismissing the charges, right?
Objection relevance.
Goes to his
Overruled.
Yes, that's the point. I was aware from before. So when this occurred, it wasn't necessarily something new to me. I was already aware that there was some history.
You mentioned a couple of dates when you were testifying earlier. We talked about you getting into the case somewhere around October or November of 2022. Is that about right? And when I say get into the case, when you were healthy enough, right,
Correct.
to kind of resume your practice and get into Mr. Sledge's case.
Yes, sir.
Okay. By the time you would have interacted with him or started representing him on this case in either October or November of 2022,
Mm-hmm.
he would have been in jail for a number of months, true?
Correct.
He would have been in jail at the Fulton County Jail, true?
Correct.
And since he was in jail at the Fulton County Jail, that presupposes, and you know, that he did not have a bond.
Correct.
Now, if you're in jail and you don't have a bond, you stay in jail, true?
Correct.
The only way you get out of jail, if you're in jail without a bond, is you either, your case gets dismissed, right?
Correct.
Or you negotiate some sort of plea or deal that gets you out of jail, right?
Correct.
Or you go to trial and you get acquitted and that gets you out of jail.
Correct.
Mr. Sledge wanted to get out of jail.
Yes.
He had been in jail for a number of months by the time you spoke to him, and he was anxious about getting out of jail, wasn't he?
Objection, counter, asked, answered, and
Sustained.
He discussed with you his desire to get out of jail, true?
objection, asked, answered, and it gets into,
Attorney-client privilege.
yes,
Sustained.
Were you attempting to get him out of jail?
Yes.
All right. Now, Mr. Sledge, you were in court previously when there was some discussion about what an offered plea is that right?
Yes,
All right. Now, and one of the ways that a defendant, Mr. Sledge, could resolve a criminal case is with what's called an offered plea, right?
yes,
Now, an offered plea, as you would have discussed with Mr. Sledge in one of his previous cases, revolves around someone saying, I'm not guilty of the charge, but I'm going to plead guilty because it's in my best interest. Is that right?
correct.
Right. And you would agree with me that entering a plea of guilty, whether it's under offered or just a straight guilty plea, can sometimes be in a person's best interest, right?
Oh, absolutely.
And that may sometimes be regardless of whether they consider themselves to be guilty of the offense or not.
Objection,
True.
Your Honor, relevance.
Correct.
Overruled.
Correct.
Because as you've testified previously, people enter pleas for different reasons. Isn't that right?
Correct.
You having, were you the one who did Mr. Sledge's bond hearing, or was it another attorney?
It was probably me. I just don't have it was a while ago. So.
Okay. It was in late 2022. True?
Well, you know what? No, his arrest on this, I wouldn't have been able to do the bond hearing. So I'm not sure who represented him for the bond hearing as it relates to that June arrest.
Okay.
I was thinking of the old case, but as to that, I would have to say, no, I was still on the sidelines where I wasn't cleared to practice yet.
Right. One thing that you became aware of, though, when you came onto the case in late 2022, is that, as you indicated before, Mr. Sledge did not have the resources to go to trial.
Correct.
And it is true, as he testified. Did you hear his testimony about that?
I did.
And did you testify also earlier that you knew that he had limited resources and he just didn't have the resources to take this case to a year-plus trial, right?
It was something that was heavy on my mind in terms of when I'd be able to return to practice, to be able to assist Mr. Sledge, because knowing he had limited resources. And even, I guess, because of the relationship over the years, even though he didn't have the resources I would have liked to become involved in this case, I was going to do what I needed to do to help him. And therefore, even though it wasn't, a huge fee for, or resources for a big year plus whatever kind of trial, I wanted to get involved, make sure I'm here to get him out of this situation and help him in this case. So I know that was a long answer to your question, but yes, it was something actually heavy on my mind, which made me say, let me get back, be healthy and effective in making sure I can represent him.
One of the things that you would have discussed with your client, with Mr. Sledge, would have been the risks of going to trial. Is that right?
Yes.
That is certainly something that you would have counseled him to consider in regards to what decision he made. True?
Yeah, every client, we're going to have that conversation.
It is true that you would have counseled him that, hey, look, Mr. Sledge.
Objection, Your Honor, when it gets into specifics of the risks that Mr. Wright considered existed in this case, I think that is privileged information unless now Mr. Sledge has waived.
All right, well, Mr. Wright understands the obligations of the attorney-client privilege, so please do not reveal any attorney-client privileged information.
And I was going to say, I cannot answer that question because you're asking me something specific to Mr. Sledge.
Sure. What you knew, though, is that had he gone to trial and been convicted, he would have been facing a potentially long period of time in prison.
I would say I would know for any of my clients that when you're facing these kind of charges, the potential consequence of a conviction could be a very lengthy sentence. So it's extremely serious. So you want to make sure you can stand guard and do the best to make sure you get the best result for your client.
And that is something that you would, without going into any specifics, that is something that is a factor that you would have discussed with Mr. Sledge, true?
Again, not specific to Mr. Sledge, but to all my clients, to make sure that their eyes wide open. We got to talk about the good, the bad, all the possibilities, so that you can make sure as an attorney that my clients have a full understanding of the risk, the reward, and all the possibilities in between, so that they make an informed decision on what they want to do.
You were aware, were you not, that the state, the district attorney's office was interested in whether or not your client would testify, would take a plea and testify? You knew that, didn't you?
Yes, as of, I think the first email was sometime in November, when sort of the first communication that sort of gave us an idea that they would like to talk to him.
Were you ever present in court where any representations were made by an assistant DA that we're looking to make deals?
I first appeared in court in middle of December. That's sort of when I came back, but I also appeared on behalf of Mr. Sledge. I don't remember the details of what occurred that day, but I will say, when I reached out to the state to say, hey, let's talk, it was middle of December. So it was after, I think, that first couple court appearances in December.
Okay. It would have been after, also, there was that November 30th correspondence between you and the state, true?
Correct. I had not yet responded to them, but it was in middle of December that I essentially was now responding to them and saying, okay, well, let's talk.
And that November 30th email was an email that you received from the state.
Mm-hmm.
It was unsolicited, true?
It's easy when you have emails to say, I remember this. It may have been a phone call where it is customary that even though you may see us in court, everyone seems to be one side or the other arguing. Professionals, we call each other, we talk, we communicate about different cases we may have going on. So it was not unusual for Ms. Love or someone from her office to just reach out, call me, as sort of that first step. And I think there might have been a phone call followed by that email. But again, I just don't have a recollection of a phone call or what the conversation is, but it wouldn't have been unusual. I've known Ms. Love probably 10, 12, also maybe 15 years.
Okay.
So as one professional to another, it would not be unusual for her to reach out to me to basically see, is my client interested in something?
Now, during that period of time, from November 30th to whatever it was you reached out to the DA's office or having some conversations with them, you would have been talking to your client about what he wanted to do in regards to resolving the case, true?
With all
Can you
my,
move back towards the mic, if you don't mind?
yeah, with all my clients, I'm going to communicate to them, hey, here are communications or statements or developments, anything about their case. So again, not talking specific with Mr. Sledge conversations, it is my norm and usual that if the state reached out to me, I would have made sure to reach out to him. And more often than not, I don't like jail phones. So I don't want to be listened to. So I will try to go see my clients
Sure.
and have that conversation
At the jail.
at the jail.
I want to backtrack a little bit and ask you, you testified just a moment ago that you weren't sure as to whether or not you represented Mr. Sledge at the bond hearing in regards to this case. Is that true?
Yeah, I just don't have a memory. I may have, but I may not have. I just don't want to misstate something.
Would it help to refresh your recollection about whether or not you represented him at the bond hearing if I were to show you a document?
Absolutely.
Can I approach this, Your Honor?
Okay.
Yeah.
Yes, please.
I was going to show you for purposes of the record, what I've marked as defendants Williams Exhibit 257A and 257B respectively. I'm going to go ahead and put those to you, let you take a look at them, Mr. Wright, and once you're done, you just tell me whether or not that helps to refresh your recollection as to whether, as to who represented Mr. Sledge at the bond hearing in this case.
Yes.
Okay.
Seeing this, it does refresh my recollection.
Okay. So tell me if you would, whether or not you did in fact represent Mr. Sledge at the bond hearing in this case.
I definitely filed for bond, and I either represented him myself or I had someone stand in for me if there was an actual hearing, because I'm not sure in that time frame that I had filed for it whether I had been cleared. So I can at least state I filed for it and I either was there and represented him or I had an attorney stand in my place.
When the bond was denied.
So it's still on me. Yes.
Okay. All right. So let's jump back to December now, right?
Okay.
So we're in December, and if I heard you correctly, the state has sent you an email on November 30th. And so now you're talking to your client in mid-December to see what he wants to do in regards to the case.
Okay.
All right. At some point, you end up in court, and I'm focusing now on December 27th, December 28th.
Okay.
Because the plea was entered on December 28th, true?
Correct.
All right. The correspondences that were shown to you, well, we've been using the word iterations of this so-called plea agreement. The first one came to you on December the 27th, isn't that right?
Yes.
And so the very first time that you and or Mr. Sledge would have had an occasion to consider the state's proffered plea agreement was one day before he entered his plea. True?
Yes, and to give you detail, that day, I actually, once I received it, went to see him to go over it. And then ultimately, it's when I got back that I sent the response. So that's why you can see I received it around 5 or so in the evening. I didn't respond until about 8 or so at night because I needed to basically go talk to him and get his feedback. And
So-
ultimately, I then sent feedback back to the state.
All right. So we're talking now about maybe 4 or 5 o'clock p.m. on the evening of the 27th is when you first received from the state this plea agreement that they had drafted up, right?
Correct. That the first one, yeah.
Right. And again, this plea agreement that they sent to you with the different paragraphs and provisions was something created by them, not by
Objection,
Mr.
Your Honor,
Sledge.
asked
True?
and answered.
Sustained.
And when you went to the jail to meet with Mr. Sledge on the 27th, this would have been the first time that he had any opportunity to look at anything called a plea agreement. True?
Correct.
You would have discussed this plea agreement with him. True?
Well, again, not specific communications
Sure.
with Mr. Sledge, but with all my clients, I'm going to take the plea agreement and go over it with them. So any meeting where a plea is ultimately in the air and being discussed, that yes, I'm going to go get my client's feedback.
So by the time you see him on the evening of December the 27th, 2022, you've got a plea agreement with you. and you're gonna have a conversation with him about whether he wants to take this plea, right?
Correct.
Okay. There's still, of course, the option of him going to trial, true?
That remains an option unless and until he takes the plea.
But hanging in the air at that time, with the plea agreement on one side and potential trial on the other side, was his concern about getting out of jail to see about his sick mother, true?
Objection
Yes.
asked, answered.
Sustained.
Also hanging in the air was the possibility of him not having the resources to go to trial, right?
Objection asked, answered.
And as you would do with any client, you'd have discussed whether or not there were things in that plea agreement that the client simply could not agree to or would not agree to.
Objection
Sure.
asked and answered.
Overruled.
I would say again, not specific to Mr. Sledge, but when a client reviews a plea agreement, if there are factual allegations, because there's not always factual allegations in the plea agreement, but if there are, we're going to go over those. And if we go over those and there's some disagreement or there's some need for clarification, that's something that I will go to the state and indicate, hey, there's some issues here. We need clarification or changes or what have you so that we can make sure these are accurate.
And in this case, you actually did that, didn't you?
I did send an email to the state indicating that there are some clarifications that we would like.
Okay. So there's some negotiations now going on, or some correspondences, communications going on back and forth between you and the state, you on behalf of Mrs. Sledge and the state,
Yes,
from the 27th of December, carrying into the 28th of December, the next day.
yes,
The next day, he's actually in court.
yes,
He's brought into court, and you have an opportunity to talk to him in a holding cell, a holding area? Outside?
yes.
Okay.
He's in a holding area. And it's typical a lot of times that client will be one place, the state may be in here or in a conference room, and I'm sort of the messenger of sort going back and forth to help facilitate a negotiation.
You had the opportunity to discuss with the state that there was a factual allegation in their plea agreement that you did not want, or you wanted changed. Remember that?
Correct,
You talked about number 3.
correct.
Now, the subject matter of that number 3 revolved around
Your Honor, I object as to the characterization of the number 3, and I'd object based on vagueness. Are we talking number 3 in 1AS or number 3 on one of the other exhibits?
Sustained.
all right,
Talking about the final version.
yes, let's reference what ends up being the final version of the plea agreement. I believe that's states 1AS. Okay?
Okay.
Do you have those in front of you? I want you to be able to refer to them.
I do not have that in front of me.
No.
Okay, my question witness.
You may.
All right. Mr. Wright, I'm gonna give you what's been marked as states 1AS.
Mhm.
And I've got some questions I'm gonna ask you referring to that document, okay?
Okay,
You had a chance to see what would ultimately become stage 1AS and the conditions, the provisions, the factual acknowledgements that were part of that document, true?
yes,
Okay. Prior to the execution of that document on the 28th of December in court, you had an opportunity to communicate with the state that you had a problem, or y'all had, to use your words, some concerns about that factual acknowledgement, right?
yes,
Now, that factual acknowledgement revolves around this incident about a video where Mr. Sledge was alleged to have been in a video holding a gun, making threats to someone else, to another person, correct?
Correct.
When the state presented any of the iterations, including that last one, right, of the plea agreement, they wanted Mr. Sledge.
Objection as to what the state wanted.
The factual acknowledgement revolved around Mr. Sledge acknowledging that while associated with YSL and to support and express loyalty to YSL, the defendant, that would be Mr. Sledge, and co-defendant Demikian Garlington and Quindarius Zachary appeared in the video with another person. AS, wherein defendant brandished a weapon used in a drive-by shooting and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, girlfriend. That was the factual acknowledgement, correct?
That was the factual acknowledgement, yes.
You communicated with the state and you requested that they change that, correct? Or that it be removed.
Your Honor, objection is to compound.
Yeah.
And I don't,
Sustained.
They did not change it.
Your Honor, I object and ask that the, whatever question there was,
Can you pose a question?
Sure. When you saw that factual acknowledgement in the manner that I've just read, in any of the iterations prior, leading up to the 28th, you communicated with the state and asked them that it be changed, true?
Yes.
They did not change it, true?
No, they did not.
Mr. Sledge still initialed that, correct?
Correct. And that's an example of sometimes, as other counsel has asked, you try to get everything you want in a negotiation. Some things you may have to live with. And ultimately, this was an item where someone could try to argue whether two things are true at the same time. That is this just a boy-girl and another boy issue, or is it a YSL issue? But a decision was ultimately made that if it wasn't getting changed, we either had to live with it or stop the process. And ultimately, that stayed.
But the reason that you wanted it changed,
hold on.
when you spoke to the state, you told them that that information was not accurate, true?
True.
You told them that this wasn't the factual acknowledgement that referenced it being done on behalf of YSL, that was not true. This was about a girl.
Your Honor,
And not
objection
about-
is to the compound nature of that question.
Sustained.
You told them that that incident was not about a gang-related incident, true?
True.
You told them that it was about a dispute over a girl, true?
True.
But they did not change it.
Objection asked and answered.
Sustained.
Were you present? You were present in court when Mr. Sledge testified that he thought that he would have an opportunity to, notwithstanding his initials, explain his answers if put on the stand. Did you hear that testimony?
I did.
Did you again, without going into any privilege and to your observation, well, actually strike that. Did you have a conversation with the state about whether or not Mr. Sledge would be able to explain anything that he had some disputes with in the factual acknowledgements?
The conversation was had back when we were doing the plea, and then even since then, it's always been broadcast or at least made clear by me, hey, if there are some differences in some of the content of some of these, my client will ultimately want to explain. If you put him on the stand and he testifies, he's going to want to explain what he means, as is when he acknowledged this Because something can be true, but also be true with other components to it. It's not always just one way that one person sees it as opposed to how another person sees it. And he wanted to be able to at least explain that. I think he often referred to it as his truth. And that was really him just wanting to explain.
You discussed that with the state.
Yes,
Objection asked and answered.
Overruled. You can answer.
I would say yes. And again, sometimes the state would agree and they would make changes. Sometimes they would not agree. But it is incumbent on me to make sure, hey, eyes wide open, full disclosure, we've told you. So it was not going to be a surprise that, well, Mr. Sledge may have a difference of opinion.
It was your observation that the state wanted this plea to go through as much as Mr. Sledge did. Is that true?
Objection, Your Honor, relevance as to, and speculation as to what the state wanted.
Wasn't what he asked, overruled.
True.
I had a belief.
Okay, that's also not what was asked.
Okay. Well,
Maybe ask your question again.
And relevance as to what the state wanted.
Based upon your conversations with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement, you formed or you observed that the state was just as interested in getting this plea done as Mr. Sledge was. Isn't that true?
So objection.
Go ahead.
Objection, it calls for speculation about the state, and whatever his observation is or belief was is not pertinent to any material.
Sustained.
Was it your observation that the state wasn't really concerned with Mr. Sledge, they really
Objection.
wanted Mr. Williams?
Same oh.
Sustained.
Crazy. And I have a motion as it relates to that.
Sustained. Ask your next question.
Okay, I thought you were waiting on the emotion. All right. Before Mr. Sledge was brought out into court on that video that we saw and entered the plea, I know there wasn't a proffer session, but separate and apart from that proffer agreement, the one we talked about earlier that was mailed to you, did you ever get an email from the state saying, hey, we want to talk to him before he enters the plea?
I'm not sure if they asked, but on the same token, my client never expressed an interest in talking to him. So I can't necessarily say it was the state or the defense that kept that conversation from happening. Ultimately, the conversations really were just the negotiations back and forth.
Okay. I got a question I want to jump ahead and ask you about first and then come back to the plea. So the plea is entered on December 28th, 2022, right?
Yes.
You had that meeting that was talked about on June the 9th of 2024,
Correct.
right? At any point between December 28th of 22 and June the 9th of 2024, did the state ask you to bring your client in for an interview?
Objection, Your Honor, relevance.
Overruled.
I don't believe so. I know we didn't meet with the state until we ultimately did in June of this year. But we always just sort of figured we were standing by, and it was always our hope we weren't going to have to testify. So we were hoping, hey, we're on the sidelines and we're no longer relevant in this. And then ultimately, it was this year that they said, we need to sit down with you, and yes, you will be testifying
In 2024,
in 2024.
in the middle of the trial.
Objection, Ralph, asking.
Sustained.
Okay. How about this? Did the state ever send you any questions that they might want to ask your client?
Objections, Your Honor,
Yes.
relevance as to whether or not the state ever sent any questions.
All right, so move on to your next question.
You knew when the plea was entered in December of 2028 that Mr. Sledge was a potential witness to be called at trial. Is that right?
Correct.
Okay. And after he entered the plea, he got out of jail. True?
Correct.
Objection, asked and answered.
Sustained.
He didn't just get out of jail as a result of entering the plea, though. Am I right? There was a bond component of that also, wasn't there?
There was, but
In fact,
Your Honor,
There
I
were
ask
two-
that the witness be allowed to finish his response.
Yes.
I'm sorry, I thought you were done. Go ahead, sir.
well, I was going to say, I think the bond, we worked that out as part of the plea as well, so that was not going to be an impediment to him getting released. So in other words, it really sort of was all connected.
His plea was on count one, the RICO plea, the RICO charge, right?
Uh-huh.
He also pled guilty on count 30, the possession of a firearm by a convicted felon charge, right?
Correct,
He was sentenced on count one.
correct.
His sentence on count 30 was left open until after this trial concluded, correct?
Correct. In my practice, I find that it's not atypical for states when they do enter into an agreement with a defendant to try to have something held open so that the defendant's participation, they can make sure the defendant just doesn't show up and show out. They come and do what they indicate they're going to do. And therefore, count 30 being held open was not atypical.
Right. His plea agreement and his plea required that if called to testify, he come in and he testify truthfully,
Correct.
consistent with the plea agreement, correct?
Correct.
Because count 30 was left open in terms of sentencing, he couldn't get out of jail unless he got a bond on that charge, true?
Correct.
The state consented to a bond on count 30, didn't they?
Your Honor, I'm going to object as to characterization, and the court can check, and I will not speak on evidence, but I believe that this is a matter that.
All right. How much longer is your cross going to be? Because we're approaching the lunch hour.
More than half an hour.
Okay, let's break for lunch. And I think we've got a couple of motions to deal with. So let's say, it's 12:30 now. Let's be back at 2. All right, what I may do, because I have a lunch meeting, is let's break now and let's just come back early. So I don't know how long 2 motions and whatever else we have to deal with is gonna take. Can we all be back at 1:15?
Yes, Your Honor, safety report.
All right, I'll see y'all then.
Thank you, Judge.
Thank you.
looks like it. All right, Ms. Love, you had two different motions.
I do, Your Honor. And one of them relates to the comments by Mr. Weinstein during his cross-examination of Mr. Wright, specifically, the comment was maybe about an hour and 19 minutes and 32 seconds from when we stopped. But specifically, the comment that Mr. Weinstein made, to which the state objected, was, you don't know how the state put those words in your client's mouth. And my objection that the court sustained, obviously, is that it was an improper comment, improper statement put before the jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses. But those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something that it did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. And in as much as that statement was an improper statement in front of the jury, and it could be construed by the jury as something, notwithstanding any court's instruction, that they could take as fact, we would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with Mr.
Let's take them one at a time, all right?
Can I respond, Your Honor?
Yes.
There was nothing improper about that question to the witness, Your Honor. I was inquiring about the facts. I'm sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And I actually, well, that's all I'll say.
So I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization, because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth, but these were not things that he ultimately adopted. So the state wasn't putting those words in his mouth. So I think it was a mischaracterization. I don't think it goes so far. I mean, you objected, I sustained it. It doesn't go so far as to warrant an admonishment before the jury. But let's try to be careful in our characterizations, even when we are asking questions, all right?
Yes, Your Honor.
Okay, what's your second motion?
Mr. Adams' question to the same witness that the state objected to, but that the jury heard. Isn't it true, and I'm going to paraphrase, that you knew that the state didn't want your client, the state wanted Mr. Williams?
Mm-hmm.
That's been the lie that they've been, the narrative that has been promoted from the start. We don't agree with it or adopt it, and we certainly don't agree with the idea that we, do these things without a basis for them. So in as much as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right, and that statement was essentially it followed upon another question that was not as objectionable in this way, but that had been sustained. And Ms. Adams, she pretty much doubled down on it and said something to the effect of the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's inappropriate to have asked that witness. And I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that?
Your Honor, it was not a question it was a question that I believed was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we'd heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. What has come out and what's been of importance is this meeting that they had on June the 9th, where this statement is made that is beneficial to Mr. Williams. The part about him advising
Right.
Mr. Copeland or Mr. Sledge to take Mr. Copeland to the police.
Station.
And that's left out of any questioning of Mr. Sledge. He is asked, or he is, however it comes out. There's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked, made, or signed plea agreements where the bulk of the plea agreements, and the jury has heard at least 3 of them previously, the bulk of the plea agreements make specific reference to Mr. Williams as the head of YSL. Mr. Williams did this. There is this narrative out there that and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond, and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, they implicated Mr. Williams in some form or fashion in their plea agreements, then they were released. And so that narrative is out there. And I think that was an appropriate question to ask of this witness who has some knowledge of that.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case? Because
he is a defense attorney representing one of the co-defendants who entered into assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained. And so he does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment and by the state's narrative to be the head of this YSL organization. And he knows that the plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Well, but he also knows, I asked him one question about, was he in court when he heard the statement that was made by the prosecutor before the plea, made by the prosecutor, it was Miss Lizzie Rosenwasser at the time, where the statement was made that we're interested in anyone who wants to make a deal except Mr. Williams. We're willing to make a deal. And so he knows this. We're not doing this in the blind. He's aware of this information.
I'd like to respond.
What's that? Yeah.
I don't know of that statement that Mr. Adams is speaking about, except Mr. Williams. If he could point me to something, because I wasn't there when she said it. I wasn't even on the case, but I doubt that she would have said it. But if she did, I mean, I can't speak to that. I'd like to see it since he's made that assertion. But the second thing is, as it relates to his assertions regarding the plea agreement. Mr. Sledge, I believe, or either Mr. Wright or Mr. Sledge were cross-examined specifically on whether or not the state asked Mr. Sledge any questions about defendant Williams. And Mr. Sledge said no. And the idea that we're pushing the narrative when the state itself, as the record will reflect, elicited the testimony about Mr. Williams encouraging Mr. Sledge to take Kenneth Copeland to the police station, belies this argument that the evidence that has been brought out by the plea agreements and by the state's actions somehow or another support this, in my mind, baseless assertion by Mr. Adams in the form of, or in the disguise of a question to Mr. Sledge's attorney. There has been, Mr. Sledge's attorney could have been asked whether the state, whether the state asked more questions about one person than another, but actually he was asked and he testified that the question and answer session was more of a kind of get to know you session, and that when Mr. Sledge began talking about Mr. Williams, the state said, the only thing he said about the state is that the state said, that's not the question I asked you. And when he said something about it appeared to be a hot button issue, he later said, there was nothing that you did that made me say that. I just, based on you not asking him about that, I may jump to that conclusion. So putting in front of the witness, one, this assertion about the state's intention, because as if it's the state that's on trial and that the state is doing something that is just wrong. Is it your impression that the state don't really want your client? He wants Mr. Williams. It wasn't an effort to solicit an answer. It was an effort to put an assertion in front of the jury that was improper, and that can't be taken back. And that has been the entire.
Well, they're going to make that argument.
Yeah.
Regardless, I'm sure they did in opening, and I'm sure they're going to in closing. But I don't believe, Mr. Adams, that there was any kind of a good faith basis to ask that question and to think that was a proper question for this witness to be able to answer. But Ms. Lev, with regard to what you propose is any kind of curative or admonishment, I mean, I don't know what that would be.
I would ask that the court admonish Mr. Adams in front of the jury that the statement he made regarding the intentions of the state as they relate to Mr. Sledge and Mr. Williams were improper statements by counsel, that in those types of statements, the jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
Okay. So they weren't statements. It was a question. It was just an improper question. And 17.875 talks about statements of prejudicial matters not in evidence.
And Your Honor, it's not, there's nowhere in evidence. It was a statement that was dressed up like a question, but he made an assertion in the form of a leading question. Was it your understanding that the state really didn't want your client? He wanted mine. And the fact that he dressed it up as a question doesn't take, our position is it doesn't take it out of the realm of improper statements put before the jury that fall under 17.875 that merit admonishment at the very least, even if not rebuke, but that Mr. Adams should be admonished about that statement. It was improper and it should not similar statements, even in the form of questions or disguised as questions, should not be made about the state's intention, which one, no one else can testify about, and two, it was just wrong to put before the jury, pretending it was a question to this witness.
Your Honor, if I may respond briefly.
Go ahead.
I have this witness on cross-examination,
Yes.
and I'm allowed to ask leading questions. I will defer to the court. If the court felt as though the question was an inappropriate question, there was an objection made, and the court sustained that objection. And I abided by the court's sustaining that objection. This does not fall under the ambit of 17-875. This is not tit for tat, where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. That's not what this is. Now, I'll abide by the court's ruling, by the court sustaining the objection, but I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth in the beginning of this case, and I'll stand by that.
I'm trying to look back at what happened right before that. Give me just a second.
Sure.
It's like. Sustained was, it was your observation that the state wanted this plea to go through as much as Mr. Sledge did. The state objected about on relevance and speculation as to what state wants. Oh, I actually overruled that one. Never mind. I made it a different kind of ruling, and I said, re-ask your question. based on your conversation with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement you formed, or you observed that the state was just as interested in getting this plea done as Mr. Sledge, wasn't that true? Objection calls for speculation about the state as to whatever his observation is or belief was. It's not pertinent to any material I sustained. And then you followed that up with, was it your observation that the state wasn't really concerned with Mr. Sledge? I think it was with getting Mr. Sledge, but with getting Mr. Williams, which would also have been asking for, what the state wanted or didn't want, which I had just sustained, but asking in an even more pointed way. So it was inappropriate for you to ask that question. With regard, though, to an admonishment, any instruction I give is just going to highlight it again for the jury. So is that really what you want?
Your Honor,
Why don't I just admonish Mr. Adams privately not to pull anything like that again, or you will get admonished in front of the jury? Would that suffice for now?
Yes, it does. Thank you.
Okay. Are there other issues we need to raise?
I just like to
I'll let
say,
Mr. Steele if you want.
Okay.
just for the court, or if you'd reconsider, Mr. Copeland made it clear in his testimony that the police wanted Mr. Jeffrey Williams, that all of, he realized.
Yeah, that's a different issue though than the prosecution being just about Mr. Williams, which y'all can certainly argue all you want, but that doesn't make that a proper question to have asked this witness.
And just, okay, maybe you resolved it, but you said something I found interesting earlier. I found a lot of things you say interesting, but thrift, THRIFT versus state, seem to agree with the court's, what I think the court was saying. It's 310 Georgia, 499. It's in Division 7, like 6-7. It's a 2020 case. And it seems to say that a question asked is not contained in 17-8-75, but it says pre-termitting. So I don't think they reached that issue, but they clearly didn't reach it, as a statement. I just wanted to.
Okay, I appreciate that. And I do think that's correct. And so I'm glad to hear that an appellate court also came to the same conclusion. Thank you. Yes, sir, Mr. Sharp.
I know Mr. Adams has not finished his cross yet. I
Right.
also have a short
Okay,
cross-examination. I wanted, and as you know, Mr. Box was flying solo this morning, and I want to be clear. I'm seeking guidance from the
Okay.
court. There's an area of inquiry that I wish to get into, but I don't want to be accused of opening any doors.
okay.
Come on, help me out here. Right. Mr. Attorney Wright, thank you. Attorney Wright has testified that there was one specific, and I'm going to have to go up there to see the number. There's one specific, no, not three. There's one specific provision that he asked to be removed,
Uh-huh.
and the state did in fact remove it.
Okay,
Okay, and I'm not going to dispute anything like that. I do not plan on getting into the contents of number 8, but I do plan on asking Mr. Wright if, to his knowledge from the review of the discovery, his client made any such statement to the police and any such statement to the district attorney. And the reason I'm asking that is, and then I'm going to conclude it, so this is not a situation where Mr. Sledge said one thing at one point and it was now disowning what he previously said, but rather it's just a situation where he's never said that.
Okay,
And
so,
that's it, and I'm not going to get into contents of anything, but I just didn't want to be accused of opening the door to the contents.
I think the contents of number 8 are already in front of the jury anyway, because it's one of the factual assertions that Mr. Sledge disputed, and so those were read out, weren't they?
It's very confusing
They
because
were.
one prior version, number 8,
It's not the same as
is
the
not the
ultimate
same.
one.
So what I believe Mr. Wright what I believe him to have been saying, and perhaps I will confirm by having him point to it when I'm up there, so it won't be read to the jury. I believe he was referring to the part where he said he heard, his client heard someone say, "We caught not
Oh, yeah,
add," and then that other number 8 was added in its place. So I'm referring to the original number 8.
okay, I don't know if that was a number 8 or not.
Well,
You'll just
whatever
have
number it
to-
was.
Yeah, you'll have to, because I don't know if you even gave a number.
Okay.
But yeah, that's fine. But I mean, I think that y'all know from, and that's a legitimate question, but I think y'all already know from maybe our discussions up at the bench that I believe Ms. Love made an argument that his knowledge was based on their post-Nutt's death discussions at the condo. And and I may be misremembering it, but I think that was what Ms. Love at least indicated was her kind of basis for putting that in. So if you ask and no, he never made a statement to police, it's then possible that she gets into that. Although y'all, we are getting, I mean, could we focus on what the issues like are in this case, please?
Your Honor, when the court permits, there's one more matter that I think I want to.
Okay, so do you have any issue with if Mr. Short ends up asking, that line of questioning? You're gonna have an issue with that?
My response has to do with what Mr. Wright's answer has already been. I actually didn't quite understand what he's asking. If it'll open the door, I'm not sure what he meant. So if he could clarify so that I can respond
Okay.
clearly.
So Mr. Wright is being very clear, and I think the jury gets it, that his client disputed a fact and it was taken out by the state.
Yeah.
Which I appreciate. But I think that, heck, if as an attorney, if I heard that, I would be under the assumption that it ended up in the first place, because he must have said that previously and is now disputing it. I'm not going to get into, the state put this in there without ever hearing it out of your client's mouth. I'm not going to get into the dramatics of that. All I'm just going to try to establish is that, to your knowledge, what you asked to be taken out was something that he never said. Not just that he's denying it now, but he never said it.
Okay. Now I understand. So what my response is actually, I'm going to entail a question as well, similar. But so in states 452, while Mr. Wright was on the stand, I asked him about what we're discussing now, and he brought up himself. I don't know how number 8 got in there,
Right.
something to that effect. And he never said, obviously, I told you to check it out. He said it was an oversight on my part. But I asked him whether it preceded, whether number 460, that email that was sent at 8:43 on December 27, whether it was sent in response to states 452, which was sent at 5:06. He said, well, states 5:06 did not have number 8 in it, right?
Right.
And so that part was fine. But then when he gets to, he said the next thing he sees is states 453, which does have, it has a version of 8 in it. But not that exact language.
Right.
as we went back and forth, and he told us what didn't apply and what did apply, what number 8 ended up being was a distillation of that original statement that it contained only the part that he wasn't disputing. So it wasn't a matter of, and
Okay.
that's a matter
Now,
for
your version
argument.
is, that's what he was saying. I think that could be interpreted more than one way. But what Mr. Sharp wants to ask is, to your knowledge from your review of the discovery and knowledge of the case, did Mr. Sledge ever say, I personally know that somebody from YSL killed Nutt, right?
No.
No? Okay. No.
I'm getting everyone, I'm confusing
Confused.
everyone by
Maybe,
referring to numbers.
okay.
I understood Mr. Wright to say, I asked, and this is what the state wanted out. I asked the state to remove something,
Uh-huh.
okay? Forget about the numbers 8 or whatever. What he asked to remove was the statement that someone said,
We got him bad or
we
something.
got Nutt down
Okay.
bad.
All right.
Okay, regardless of what the number is.
Okay.
And I'm not gonna ask him what he wanted to get removed. I'm not gonna get into the contents. I'm just
All
gonna say what you asked to get removed, to your knowledge, your client never said it. And
Oh, that,
in
okay.
the first place,
Okay.
and when you were representing him, he never told the state that, he never told the state investigators that.
Okay.
Just so it doesn't appear that it's something that he said at one point and is now.
I understand.
So then the question then is not going to be whether or not his client ever said that statement that is now factual acknowledgement number 8.
Right, it's the quote that got taken out from some much earlier version. That is, I don't know where it is because there's so many different versions, but we got, that somebody said we got Nutt down bad or something to that effect.
And of course, I'm not gonna say what it says. because
Right.
that's-
Okay, but that's what you want to ask about, but you're, okay.
And so if the court could inquire if Mr. Sharp, because we have labeled them all so that they're not confusing.
Do you know what
Um,
exhibit this is gonna be on? I mean, I don't know that anybody,
Or just the date and time.
I don't know. Do you have the exhibits
do.
available?
And I gave them
for
to Mr.
review?
Sharp,
All
but
right,
if he'll just
Mr.
tell
Sharp,
me.
can you review and see what exhibit number that is? Because I don't know if it's on more than one. All right, and so if he asks that, he's gonna ask, do you know of anywhere from the discovery that might have come from?
Or in his representation, Mr.
Okay.
Sledge ever telling someone from the state that
Okay.
prior.
Which one?
Whatever the quote is.
Yes. Of course, it's in the wrong order. Okay. I know it's in Sledge Agreement Updated 2, sent 1:54 PM on Wednesday, December 28th.
All right, that's gonna be, I think, 455Y.
That is correct. 455Y. And under number 8 in
Sorry, but that is one, that is 453Y. 455Y was the one that was sent on December 28th at 1:54 PM.
That's
Mr.
exactly what I just said.
I'm sorry, I thought you said 1:45. My apologies. Okay.
So it is 455Y.
Right. And I'm not saying it's not in other versions. I just know it's
I don't
in,
know whether it is
Okay.
or not.
I
but
just know
okay.
it's in that one.
All right. And what number was that, please, sir?
It's number 8.
So it's number 8 in 455Y. Okay,
Correct. But of course, not number 8 in the final version because it's not in the final.
right.
Okay.
Okay, so you understand what he wants to ask is that, and I don't know what you think that might open the door to or not.
I think it might open the door to the fact that Mr. Sledge has testified to the fact that he was at the condo with a number of people, one of which has given a statement that Mr. Kendrick and Mr. Stillwell both indicated that they had killed Donovan Thomas using this language. We caught that in down bad. And the fact that Mr. Sledge acknowledged being at that condo during that time,
Okay.
if he starts asking, and he being Mr. Sharp, asks, did your review of the discovery reveal that your client made this statement, then it doesn't have any relevance, given that, one, it doesn't show up in the final version, but two, if his whole purpose is to find out the basis for the state putting it in here first, then I can inquire further about what his client did say and what his review of discovery did reveal, whether or not that statement was alleged to have been made during a time his client was alleged to have been at the condo with the person alleged to have made it. So if that's his only reason, then that's what I would offer up. It's opening a door into. That's just from hearing what I'm hearing so far.
Once again, I'm not getting into the contents, and Your Honor, to answer the question, of course it doesn't open the door, but I was just doing this out of an abundance of caution, and obviously the state is trying to jump through a door
And so
that's
is
not
your
open.
question going to be to Mr. Wright, from however you phrase it, whether Mr. Sledge ever said he personally heard that?
I am going to say, I'm not going to use the words personally heard. I'm not going to use,
All right, what are you going to ask?
I'm going to say, Mr. Wright, on direct examination, you talked about requesting that a
Something
part
different.
of
Yeah.
number 8 on 455Y be removed, and the state removed it.
Right.
And without getting into contents about what it said, is this something based, and I'm going to get into, you're his attorney, you get discovery. Is this something based on your review of the discovery that he ever said to the police? And I'm not going to say what it is. I'm just going to say what you asked to be removed. Is it based on anything he ever said to the police? Is it based on anything that he told to the district attorney or any DA investigators? And I was just going to conclude it and say, Mr. Wright, so the thing that you asked to be removed, it's not a situation where Mr. Wright, Mr. Sledge allegedly said something and was now going back on it. It's a situation where Mr. Sledge had never said such a thing. And that's it. And I'm not going to say, oh, the state was doing this and that.
Okay.
I'm going to keep it very simple.
Okay.
That's fine, but we've never alleged that the state, that Mr.
Okay.
Sledge.
I think they just want to establish what he just said as his final sentence, that Mr. Sledge didn't one time say it and then disavow it.
Right.
And given that it's not something that has been put before the jury, what it is, I don't know how it's relevant.
Well, I mean, Mr. Sledge's credibility is obviously at issue.
Right. And the state is
but-
putting it before the jury that Mr. Sledge has disavowed what's been put in front of him. And I'm just trying to clear it up in front of the jury that
It
he's
is,
not.
yeah,
This
I
is-
understand. It's fine for you to ask that question. Do not ask it in a way that suggests that the state has no factual basis for having ever suggested maybe that's something he could
I'm not going to do.
agree to,
gonna
because
do-
then I will let her get into, here's why we said this, okay?
Completely understand.
All right, everybody understand that? That's gonna apply to anybody that might examine Mr. Wright. Okay,
So,
all right, what else?
so Your Honor, once okay, I'm not going to follow up. I'll just redirect if necessary. But number 3, Mr. Wright made a particular statement on cross, I think, as it relates to number 3, or it may have been under rect, but I think it was number 3, and Mr. Adams followed up on it. And the question was, you asked that number 3 be changed, and then number 3, the state refused to change it. Now, given that that assertion has been made and has been affirmed by the witness, we believe that the content of number 3, which I think has already been put before the jury because it was played. I think that the content, just number 3 alone from Mr. Wright's December 27th, 2022, 8:43 p.m. email to the state. The statement that he makes, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that, not denying the video, but the real issue was the girl. I think that at this point, the language of what Mr. Wright responds with becomes very important because of the characterization made during cross-examination, which was that Mr. Sledge asserted that number 3 was false. And Mr. Sledge has stated that he feels like it was false. And then Mr. Wright asserted that it was false. But the language that Mr. Wright used to correct that assertion does not, it does not assert that Mr. Watts was not a rival gang member. In other words, it does not dispute any material aspect of it. So the only part that we would be asking to Mr. Wright to tell the jury verbatim is what his response was to number 3 so that the jury can fully understand and appreciate what it is that everybody is saying the state refused to change.
I can make this easy. I'll read that number 3 from Mr. Wright's email out loud to Mr. Wright on cross-examination, and the jury will get to hear it. I'm fine with that.
And on behalf of Mr. Williams, I don't have any objection to that. I asked the question, I believe, and it was specifically because Mr. Wright had on cross-examination said that on that one, number 3, he specifically asked that it be either accepted or changed. And so I don't have any objection to that. I think the subject matter of that language is appropriate.
All right.
Okay, good. Then that means I can get, okay.
All right, sounds good. Anything else? Okay, let's get Mr. Wright and the jury. And Mr. Adams, you
Your Honor,
can come on up too.
Can we approach really quickly regarding a witness? Hang on.
Yeah. Hold on the jury. Mr. Wright can come on in.
I got you.
Thank you very much. Sean, be seated, and Mr. Adams, you can continue your examination.
Thank you. Mr. Wright, welcome back, sir.
Thank you, sir.
All right. I think when we left off, Attorney Wright, I was asking you, we had gotten to the point where I was asking you questions about the actual plea on the 28th of December. Okay. So I want to pick up there. All right. At the end of everything, all of the discussions, the plea agreements, conversations with your client, ultimately, Mr. Sledge entered a guilty plea, correct?
Yes,
And he was sentenced, at least in part.
yes,
And he was released from prison, from jail, true?
yes.
All right. Part of his sentence, requirement of his sentence was he had a curfew. Is that right?
Maybe so. I'd have to refer to it, but that sounds
Okay.
reasonable.
10 to 6 sound like what you remember, if you remember that?
Again, if the curfew was in place at the time he first got released, yeah.
Okay. It's fair to say that even after he had entered his plea and had gotten out of jail, he had conditions on him pursuant to his plea and sentence, true?
Correct. And it was always an unknown, is he going to have to appear, testify, and, go through this?
But that was, of course, something that was, and I'll use the phrase hanging over his head. That was a condition that was upon him.
Yes.
The possibility of him testifying, true?
Yes.
And of course, the discussions that you would have had with the prosecutor and with your client, again, I'm not asking you specifically what you told him, but subject matter is that if he were to testify, it would be expected that he would testify truthfully and consistent with that plea agreement, correct?
Correct.
All right. Now, it would be fair to say, and you tell me if I'm right or wrong, that you would, of course, make him available to speak to either the state and or the defense in preparation for his testimony.
Correct.
And previously with other clients, and I presume with Mr. Sledge, it would have been incumbent upon you, and you would have discussed with him the necessity of testifying if he were to be called in, testifying truthfully, correct?
Correct.
You've heard the phrase before. He's used the phrase, and it's been here in court, where he said he was of the impression that he would be able to get up and testify to, quote, his truth. You heard that?
Correct.
Okay. You knew and you understood, based on the discrepancies that you had with the plea agreement, that his truth might not necessarily agree with the verbatim reading of the plea agreement.
Objection vague as it relates.
Sustained.
I'll rephrase the question. You knew that he did not agree with everything that was in the plea agreement, correct?
I understood that he did have issues with some of the factual allegations that were contained in it, yes.
Okay. And so moving forward then from that period of time, December of 2022, to when the state made contact with you about speaking to Mr. Sledge in June of 2024, you made him available at that time, true?
Yes,
And if I heard your testimony and the testimony properly, this was a meeting that took place at the Starbucks over in Fayetteville, correct?
yes.
Would have been yourself, Mr.
We've
Sledge.
gone through who it was,
Asked and answered.
sustained.
All right. You testified that the meeting that was had with Mr. Sledge at that time was approximately 40 minutes. Is that accurate?
Objection, asked and answered.
Your Honor, I'm entitled to a thorough and sifting cross-examination. I'd like to be able to explore that because it has been made an issue by the state in their questioning.
Okay, I don't know that the length of time of the meeting has been made an issue. Just go on to what it is that you want to get to with this witness and questions.
Yes, Your Honor. Did you describe in your previous testimony this meeting as a getting to know you sort of session?
Yes, it didn't seem like a detailed question answer preparation kind of meeting. Is more of a feeling each other out, getting to know you kind of meeting, and giving you a general idea of, hey, you're going to be testifying, and therefore, I'll be asking you questions, and so we need to get a sense of each other.
Was there a discussion from the state of, did they advise Mr. Sledge of what they would be asking him?
No, there were general questions again, but it was not often when you think about witness prep, you think, hey, got 20 questions here. The 20 questions on it wasn't anything like that. It was really more of a introduction to each other, get to know you kind of meeting.
It did not appear to you to be what you would consider a witness prep session.
Correct.
And that was on June the 9th of this year, correct?
Objection, asked, answered.
Sustained. Mr. Adams, go ahead and just focus in on what it is that, we're all familiar with what he's already testified to.
At any time after June the 9th of this year, and when Mr. Sledge was brought in to testify, did the state ever, in fact, conduct a prep session with him where they asked him or discussed questions they might ask him on the stand?
Objection,
No.
relevance.
Overruled.
No. That was, like I said, we met the one time, and then we've appeared for trial. And to be clear, we appeared to trial a couple times, but we weren't called, but they did not ask questions or anything. We just sort of waited.
Mhm.
So again, trial was really the next instance of any communication between the state and my client.
Did Mr. Sledge at any time ever indicate that he would not comport with his plea agreement and come in and testify? Did he ever exhibit any reluctance to come in and testify?
No,
Did he ever attempt to avoid a subpoena or to avoid reporting when he was asked to
Objection,
report?
relevance.
Overruled.
no. In fact, for us, in our posture, we wanted to make it clear if they need to meet with us, see us, when we need to come in, we were always going to make sure we are there and make ourselves available so that at all times it's clear we're fully cooperating.
During the course of that meeting, you described, and I'm going to use your words, that when Mr. Sledge started talking about what Jeffrey Williams had said about taking Woody down to see the police, that, quote, the prosecutor didn't seem to like that topic.
What I said then were words to the effect, and I'll say it again now, that she made it clear that wasn't what she asked him, which is true. That wasn't the question that I heard her ask him. But ultimately, my observations were that it was a topic that she wasn't asking about. And again, it just sort of raised a red flag for me that, is this a hot topic? There's something to that.
When Mr. Sledge testified that the prosecutor said to him, quote, "I'm not going to ask you about that." Do you have a specific recollection of him, of that being said?
What I can say is, again, I didn't hear Ms. Love say that, but I do know my client indicated that's what he heard. So we were both present, but we heard things differently. So yes, he has always contended that's what he heard. And again, to the extent that what I heard was not the same.
Did he contend that prior to him being put on the stand? Let me rephrase that question so it's clear.
Okay.
You heard his testimony when he testified to that on the stand, am I right?
Yes.
Had he indicated that to you, that sentiment to you, that that's what he heard prior to him coming in here and testifying?
Yes.
I want to, almost done, just have one or two last questions for you, Mr. Wright. I want to jump back to early December of 2022, when you were having the back and forth with the state
Okay.
in regards to the plea agreement. And if I heard you correctly, that was between essentially the 27th and 28th, is that right?
Yes.
Do you recall stressing to the state or sending them a message, specifically telling them that you were ready, he was good, Mr. Sledge was good to take the plea, he didn't want any media, and that he just wanted to get back to his family? Do you remember expressing that sentiment to the state?
I did.
One moment, please. Attorney Wright, thank you. That's all I have at this time.
Thank you, sir.
Thank you. Mr. Sharp?
Good afternoon, Mr. Wright.
Good afternoon.
Attorney Wright.
Good afternoon.
May I approach to just see what the witness has in front of him?
You may.
This is 1AS, which was that final. These are just my own little notes. This shouldn't be. These are all just my own notes.
Yeah, go ahead.
Okay.
Just put these in front of you.
Sure.
So your hand. Thank you, Your Honor. Okay. Attorney Wright, on direct examination,
Mhm.
you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several,
Mhm.
but there was one in particular that the state changed for you, correct?
I need you to give me a little more info
Okay.
on which one.
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. I'm not seeing 55. Let me, one more time. 6.
State's just handing it to me.
Okay,
On approach.
gotcha.
That's what they done.
It is.
I believe it's 455Y.
Yes,
Yes.
yes,
Now, we're throwing a lot of numbers at the jurors.
okay,
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgements, correct?
no,
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
yes,
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
yes,
And you were able to see what your client may have said or did not say to any police officers.
correct,
Okay, and certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
okay,
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
yes,
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it. Okay, you with me?
yes,
The state removed it, we agree?
yes,
Okay, that part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement, and that was one
Okay.
of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but to your understanding, he never said it.
Correct,
Okay. And so, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection asked and answered twice.
Oh,
that's correct.
Thank you. I just want to talk to you about the timeline of you receiving the plea offer in an actual pleading this case, okay? You received the first version of the factual acknowledgements, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes,
Okay, and that was the day before the plea was entered.
correct,
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Rice Street, the Fulton County Jail, to discuss the plea offer with your client.
yes.
Okay, Mr. Sledge. And do you recall how long you met with him that day?
Now that I don't know, it would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave. And then, of course, as I said, later prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Rice Street?
Yes,
Okay, and as an attorney, or when you met with Mr. Sledge, you were on one side of the booth, there's a glass.
Objection relevance is to.
I'm discussing their ability to go over this document.
overruled.
There's a thick glass barrier in between you and Mr. Sledge for this meeting,
correct,
and he's on the other side of the thick glass, correct?
correct,
And of course, you have to talk loud, but you
Yeah.
can hear each other, correct?
correct. And let me at least so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right.
That is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time and go over whatever we need to go over. I'm sort of stating it because it's so long ago. Is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay.
But I just wanted to point out that, yes, we can talk as well as hand stuff to each other to review.
Well, let's let the jury know what we're talking about here.
Yeah.
So if the attorney booth, if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the main difference is there's no pass through in those
Correct.
booths.
Again, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course, when you met with him on the 27th, met with Mr. Sledge on the evening of the 27th, you had whatever version of the plea agreement was in effect at that point, but not the final version.
Correct.
Okay. All right. Could you refer to 1AS
Okay.
for me?
I have it, sir.
Okay, thank you. You would agree that in the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes.
And he was facing 15 years to serve. He was sentenced. The agreement was 15 years to serve on probation, correct?
Correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld
Yes.
and would be dismissed if he fulfilled the agreement.
Yes.
Okay. At this point, sentencing is still withheld, correct?
Correct.
And the maximum he's facing on count 30 is 15 years, correct?
Yes.
Okay. So right when he testified earlier today, he had a 15-year sentence hanging over his head as well as the probation.
Correct.
Okay. And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time is already ticked off since the agreement. But generally speaking, it's 15 plus potentially another 15.
So, and at this point, if he's done a year on probation, it would be 29 years instead of 30 years.
Correct.
Okay. Now, you indicated in your review of the final plea agreement, there was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement, you missed.
Correct.
And, well, I'm not going to ask you to speak on behalf of your client, but you missed it.
Yes, I can always say that I missed it. And had I seen that, I would have immediately, because it was of a certain subject that from the very beginning, we had sought to exclude from this. But ultimately, for whatever reason, we missed it.
Okay. Can you, in sentencing acknowledgements, number 5 on that final agreement, defendant sentencing acknowledgements,
Yes.
this final plea agreement between Mr. Sledge and the state, as reviewed by yourself and Mr. Sledge, indicates that your client is facing as much as 35 years in confinement. Isn't that correct?
Correct.
That's what the agreement says.
Correct.
Okay. In fact, he's facing 30, maybe 29.
Correct. It would have been a max of 30. So 35 was incorrect.
Okay. So,
Your Honor, I object to the characterization, the language. I'd object to the characterization, and I don't want to speak further, but the question was posed whether it said he faced 35 years, and that is an incorrect characterization. I can,
Okay, do you want to rephrase?
does the document say that if your client does not fulfill the obligations of this agreement, it may result in defendant being sentenced to serve as much as 35 years in confinement in the Georgia Department of Corrections?
That is what the document indicates.
Okay, is that your client is facing 35 years?
I think it would be a more correct statement to say 30, but point is 30 or 35, a whole lot of time.
Well-
But yes, I think the correct number is 30.
All right, you're making my point for me.
Gotcha.
You signed an agreement where your client was facing, you and your client signed an agreement
Mhm.
saying that your client was facing 35 years.
Correct.
And he was really only facing 30 or less.
objection, ask
Okay.
and answer.
Yes.
Sustained.
Your client on that final agreement, there's a word that's crossed off and initialed by your client, correct?
Yes.
Okay, begin was changed to being. It's just switching the letters, right?
Yes.
Okay. And that was crossed out and written and initialed by your client, correct?
Correct.
All right, and you've reviewed the video tape. You were in here when the video was played
Well,
of your
yeah.
client taking a plea?
I was there.
Okay. That was something that Miss Love caught and instructed Mr. Sledge to cross out an initial, correct?
That sounds correct. Yes.
All right, that wasn't something that was caught by your client.
Correct.
Okay, Mr. Wright, you, in addition to what I first asked you about number 8, the portion of number 8 that you pushed back on the state and they changed, you also pushed back to acknowledgement number 3 on the final plea agreement, correct?
Correct.
And Your Honor, may I go back?
Yeah.
Okay, and number 3, which you pushed back on, regarded the video that your client made with Quindarius Zachary, where he was, we'll say, threatening a gentleman by the name of Kelvin Watts, correct?
Correct.
Okay, and you're aware that the factual acknowledgement indicates that your client, while associated with YSL and to support and express loyalty to YSL, made this video.
Correct.
And it indicates, the acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Okay.
Your Honor, I'm going to object to characterization.
Sustained. I mean, if you read it carefully and then rephrase.
On behalf of YSL, defendant threatened to harm a person named Kel.
You can ask that.
Okay, but the acknowledgement indicates that on behalf of YSL defendant, that would be your client, Mr. Sledge, threatened to harm a person named Kel, correct? That's what the acknowledgement says.
Yes.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct. Actually, we began taking issue with that characterization from the very beginning. And this was, I think I testified, an example of where we felt one way, the state felt another, and that was one of the examples where it was not changed.
Right. Okay. Do you have the emails? Actually, this might be.
460 is right here.
Do you have 460 in front of you?
Yeah.
No.
462, 461.
He-
One moment.
This is the only 460.
Ms. Love gave me this one.
Oh,
I'm gonna
okay.
approach if Your Honor will allow. I'm handing you what's been marked as 461.
Yes.
Going to read to you from your email what you said about acknowledgement 3 to Ms. Love. And this email was sent on December 27th at 8:43 p.m., correct?
Yes.
Okay, and this is the night before Mr. Sledge entered his plea, correct?
Yes.
You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the issue was the girl. Is that what you
Yes.
wrote? And is that verbatim?
Yes, that was verbatim.
Okay, so the point you were trying to get across is you're not denying that your client, Mr. Sledge, made the video,
Correct.
and you're not denying that he had an issue with Kel,
Correct.
but that issue was about a girl.
Yes.
And you ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
Correct.
They were unwilling to take out that it was done on behalf of YSL,
Correct.
and they were unwilling,
Your Honor, my objection is vague when the question is they were unwilling to take out that it was done. And earlier, Mr. Sharp referenced video. If you could just clarify what he's saying.
Sustained.
okay, they were unwilling to change the factual acknowledgements on your client's plea that he was to sign the next day, right?
Well, again, some changes were made, but as to that specific one,
I'm talking,
that was one example of where they were not willing to change it, even though we had a difference of opinion as to what it was about.
and,
So the it is still unclear. So
and
if-
factual acknowledgement number 3, I'm sorry, yeah.
Okay.
Yes, my objection was could they specify what it we're talking about?
And it may help.
Factual acknowledgement number 3, which relates to the video that was made
Yes.
with your client and Mr. Zachary in it, correct?
Yes.
Okay. The state was unwilling to change the language that it was done to support and express loyalty to YSL, correct?
Correct.
And they were unwilling to change the language that it was done on behalf of YSL.
Correct.
And Your Honor,
Yes.
again, I object.
You can clear it back up on redirect, or are we already? Yeah, that was,
I haven't
you
done a
still have redirect, so you can clear it up then.
They were unwilling to change the language where it said, wherein on behalf of YSL, defendant threatened to harm a person named Kel because of that individual's association with a rival gang. They were unwilling to change
All
it,
right,
right?
all right. I think that the state's objection is a valid one, and I don't know if you want to, if you need direction, but why don't y'all approach? Yeah.
Give them back the exhibits.
Okay, Attorney Wright, do you remember at this moment, in your email, you did not indicate specific changes that you wish to have made, correct?
I'm going to object.
Actually, in my email, the way I even described I put, here are recommended changes, and then I went number by number, all the way 8 through 13 for the agreement I had at the time.
I get it. It's not like you went through it like you do in Microsoft Word and mark it with red or anything like that, like an editor would, correct?
Correct.
Okay, but the point you were conveying in that email was it was not gang related, correct?
Correct.
And it was over a girl.
Correct. As to that issue number 3.
As to number 3. Okay. And ultimately, the final version of Mr. Sledge's plea agreement includes language. You would agree that it includes language that indicates that the video and the making of the video and the threats were gang related.
Correct. That number 3 is an example where there was not a meeting of the minds with the state, and that's where they did not remove the information, consistent with what we were suggesting be removed.
And the gang related versus a girl was where the meeting of the minds was not happening, correct?
Correct. I mean, ultimately, the state included sort of both things in there where we were saying it was really about the girl.
Right. And you told Mr. Sledge that he could explain this later to a jury.
Objection, Judge. One that answered in province of attorney-client privilege.
Then attorney-client privilege.
Okay. Mr. Wright, from your dealings with Mr. Sledge, you are aware that Mr. Sledge did not completely agree with factual acknowledgement number 3.
Objection asked and answered.
Sustained.
On the date that he pled, he did initial that factual acknowledgement, correct?
Asked and answered.
Your Honor, this is the first time I'm questioning this.
I know, but lots of other people already have, and we've gotten that information at least a couple of times.
Okay.
I mean, you're welcome to ask whatever it is that you were leading up to.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds, but his choice was to either walk away and proceed with trial or enter into the plea agreement.
To go home, Mr. Sledge would have to live with that as part of the negotiations, correct?
Objection, Your Honor. That part is asked and answered. And
Sustained.
All right, here's my question. Is it fair that Mr. Stillwell would have to live
Objection,
with
Your
your
Honor.
client?
Asked and answered.
No.
I'm sorry. That is not what I meant to add. Objection, relevance and improper question. Is it fair that Mr. Stillwell will have to do anything is an improper question for this witness. So forgive me for
Sustained.
Was Mr. Stillwell a party in these negotiations?
objection. That is, again,
I'll permit that question.
Was Mr. Stillwell a party in these
No.
negotiations?
And-
Was this Was your client signing a factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
Objection, one,
Sustained.
The signing of these incorrect factual acknowledgements, you would agree that it affects more people than just Mr.
Objection, Your
Sledge,
Honor.
correct?
Overruled.
I will state this, any person in a case where there are multiple defendants, once they enter to a plea agreement that includes certain factual stipulations, that can impact all the defendants, not just themselves. So, to your point that yes, when Mr. Sledge was completing his plea, his focus was on him. However, there are effects or ramifications that could affect others.
And your
And-
focus
and Your
was,
Honor,
and
my
your focus was
Hang on
on
just a
him.
second, hang on.
and my objection was to the characterization of the incorrect or improper factual acknowledgement. So the answer, I think, sort of dealt with, but my objection was that that was a mischaracterization or improper characterization.
Was factual,
Well, the jury's heard the testimony, so.
was factual acknowledgement number 3 completely correct from your client's perspective?
We indicated that we took issue with some of number 3. Some of it we were acknowledging and some of it we took issue with.
And he initialed it and he got to go home.
Correct.
Objection. that's
And
the answer.
it affects these other gentlemen back here, correct?
That's the answer.
Sustained.
No further questions.
Okay, does any general questions, Mr. Williams or Mr. Harvey? Okay, all right. Anybody need a break before we do redirect? Okay, let's take a quick kind of 10-minute break. Try to be back here close to 3.
County Manager.
Yes.
Okay.
All right, we'll take a quick recess.
Joke, no joke. We waiting for them to come back. They should be back any second now. Let's go, Judge. Where we at? Where we at? We back, y'all. We back.
And Ms. Love?
Thank you, Judge. Mr. Wright, you were asked on cross-examination by Mr. Sharp, I believe, regarding factual acknowledgement number 3 that was contained in the final plea agreement that your client signed. Do you recall that?
Yes.
I want to ask you whether State's Exhibit 452 Yankee, which was sent at Tuesday, December 27, 2022 at 5:06 p.m. as indicated by its label, was that document, the document that preceded the email in 460 Yankee from you dated December 27 at 2022 at 8:43 p.m. I'll let you look at that. Paying particular attention to number 3 in State's 452 Yankee.
Yes, it does appear to be number 3 in exhibit 452 Yankee is what my email note was referring to.
All right. Would you please read exactly what number 3 in State's Exhibit 452 Yankee says that was sent to you before you sent the email in 460 Yankee?
Okay. While associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikian Garlington and Quindarius Zachary appeared in a video with another person, AS, wherein the defendant brandished a weapon used in a drive-by shooting, and wherein, on behalf of YSL, defendant threatened to harm a person named Kel because of the individual's association with the rival gang.
Now, exactly what did you respond with relation to number 3 when you sent that email in 460 Yankee?
Objection. That's
Your
been
language.
answered.
What'd you say, Mr. Adams?
Asked and answered.
I'm gonna allow some leeway.
Go ahead.
In 3, I said the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that, not denying the video, but the real issue was the girl.
On any part of 460 Yankee or any other communication you made with the state, did you ever assert on behalf of your client that Kelvin Watts was not a rival gang member?
No, I did not go into, no.
Okay. And
He can explain this.
Your Honor, I don't mind explaining, but I wanted to ask, with the court's permission, certain questions that are frankly binary questions, yes or no, and then if he could be allowed to explain, I would
Okay,
just
well, he said no, and he was
Okay.
about to explain, so you may follow that up your no if you want to with something else.
go ahead.
I was simply going to say no. But again, the whole point I was trying to make is that it wasn't, from our perspective, really a gang-related issue. It was a girl-related issue. And then ultimately, you did change it. However, the change ultimately sort of included both. That it's a girl issue, but you also kept the fact of some of the YSL and gang contention. And that was just what I would say is sometimes in negotiations, you agree to disagree about, what was at issue.
Okay. I'm going to ask you the next question. Did you ever indicate in any way on behalf of your client that your client was not associated with YSL as stated in the first part of Section 3 of 1AS, the factual acknowledgement?
There's never been a time where I've ever contended or represented to you that my client was not YSL.
Okay. And is there ever any indication from you through your client, from your client through you to the state that the portion that says where a defendant brandished a weapon used in a drive-by shooting is incorrect, inaccurate, or false?
The answer is no. And further, again, we took no issue with the video. The video is what it is. The issue was just, we were saying sometimes what the motive was. The motive was a girl-related motive, not YSL. Yes, he may be YSL, and yes, the video he does.
I'm gonna object.
Hang on just a second.
I'm gonna object to the response that he may be YSL, that invades the province of the jury.
Your Honor, we're talking about his.
Overruled.
Okay, go ahead.
Maybe, again, it's contended he's YSL. Maybe, and the video is what the video is. We were simply taking issue at the motive or why the video ended up being created had more, it was focused because of this girl situation between two guys.
Okay.
The fact that Kel or my client or whoever they are was a secondary and what we said not the primary issue.
Okay. Did you ever indicate on behalf of your client in any fashion, whether in 460 or some other way, that the portion wherein on behalf of YSL defendant threatened to harm a person named Kale was false?
No.
All right. All right. So is there any statement contained in State's Exhibit 1AS, Section 3? Is there any portion of 1AS, Section 3 that your client, through you, contended was false at any time that you conveyed to the state?
The part which says that ultimately his actions in the video.
Wait a minute. Where's the word ultimately in that?
Okay, well, no,
Sustained.
Okay.
He's
Okay.
trying to explain it.
okay, I'll just start by reading and then I'll pause and explain the part. While associated with YSL, comma, and then here's the part, and to express support and loyalty to YSL. That part is, again, it was not a gang motive. That was the part that my comment would take issue with, that he wasn't shooting this video or making any comments or doing anything. This was about the girl, not about trying to support or express loyalty to YSL. Now, the rest of quite honestly, the rest of it is essentially just describing the video. It's correct. And then ultimately at the very end where it was added, had begun a relationship with defendant's ex-paramour. That was correct. So the only issue was an inference that it was in the furtherance or in support and express loyalty to YSL. That was the only part that we took issue with. So that's where, when I say sometimes there's something where we agree, but also part of it disagree. That was the part of disagreement.
and to not split hairs, but did you at any point say in your email or anywhere else that that part is factually incorrect?
No, but also understand, my email came the day before. As we started getting into these later versions, I was here in court. I wasn't sending emails. At that point, we were communicating verbally back and forth because we were sort of both here. But the point being is, that was something that my recollection is, hey, we changed it to the extent we're going to change it, and that ultimately you weren't going to change it further or, eliminate that. So my client, as he, I think, testified to, would say, look, some parts I may not have liked, and guess what? When asked, I'll explain it. But ultimately, I don't want to not do a plea. I want to get the plea done so I can move forward. And that's that point of compromise.
Thank you for explaining that. All right.
Your Honor, I would also at this time ask the court to conditionally admit 452, 460, and 453, not for publication at this time, but subject to additional restrictions as the court sees fit. And we can discuss off. Outside the presence of the jury.
Conditionally admit them. If we want to talk about them more, we can talk about them more.
Yes, Your Honor, thank you. While you were on cross-examination, you testified that some of the factual allegations that were contained in the final plea agreement were not ones that you had agreed to. But on direct, am I correct that you said number 3, you asked to be changed and it was changed, but not exactly like you wanted?
Mm-hmm.
And then number 8 was one that you said today that you missed back at some point when you were reviewing the document.
That is correct.
Okay.
I have said today that number 8 was missed.
Okay.
And a review of it versus our earlier comments to you, they can't be reconciled. I mean, in other words, it's clear that that was not something that we would have anticipated. In other words, it was something we objected to and wanted removed. Ultimately, it reappeared in that final version. We did sign it. Again, I'm not taking issue. We missed it. And unfortunately, had I seen it the day of, I would have paused, stopped everything and said, this is a hard stop. We got to figure this out.
We'll come back to that in just a moment, okay? Other than number 3 and number 8, do I remember correctly that everything else your client through you acknowledged was
Objection, Your Honor, asked
accurate?
and answered.
Sustained.
When you spoke of some of the factual allegations, were number 3 and number 8 the only 2
Asked
you
and
were?
answered.
Sustained.
Outside of what's contained in the final 1AS, is there any other thing that you asked the state to change that we
Your
did
Honor,
not?
asked and answered.
I think that was also asked and answered.
I did. Okay, we'll
Objection.
move forward. Now, as I said, when you mentioned number 8 being something that you had not seen before, are you able to tell the jury the first time that you can now recall paying attention to number 8?
Number 8, when you were questioning my client and number 8 came to light, one of the first things I started to do was go back to read to figure out where that came from. And of course, my reasoning without going into the content was that was one of, from the very early things that we said, hey, this is not accurate. And then I'm thinking, where'd that come from? But I went back, I realized it was there. How we missed it, how I missed it, I don't know. But apparently I did.
If I show you number 8 on 455 Yankee, an email dated December 28th, 2022 at 1:54 p.m., are you able to recall whether this was a document that you reviewed while you were actually in court?
I believe that was one that I did review while in court. I think you said 155?
Yes, sir.
Yes,
455.
455.
Did I say one? Thank you.
I don't know.
455, yes. Now, without reading out loud number 8,
Okay.
read to yourself number 8. And after you've done so, would you please tell the jury whether number 8 under factual acknowledgements under 455 Yankee is something that you asked the state to change?
If we,
With, just
okay.
because I can't have you read it.
No, I'm not going to read it.
Okay.
But what I was going to say is, having read it, ultimately, only the very final part, the last sentence, really the and then everything after that is the only thing we would have asked to be removed from this paragraph. So essentially, you could say almost the last 2 sentences.
And so,
$455 number 8. Your Honor?
Yes.
I'm going to object under 403, misleading the jury. Mr. Wright has been referring to number 8 on the final agreement. Now we're talking now. Ms. Love is trying to talk about number 8 on a prior
Okay.
version, which is not the same.
I hear you. I think she was maybe about to ask some questions to clarify that.
I was, Your Honor, and just to be clear, because there was this cross-examination about what was agreed to, what the state refused to move.
Right.
So this, we believe, is a proper line of inquiry, and we'll try and keep it as concise as we can. So, may I continue?
You may.
So, Mr. Wright, when you speak of the change you requested on number 8 of 455 Yankee, does number 8 on 456 Yankee, is that the difference, and is that the line that you're referring to that appeared in the final version?
Well, they are 2 completely different statements.
Right. And does 456 Yankee contain the line that is now contained in the final version?
No, what I can see is that in 455 Yankee, where item 8 in that document was the one we had been talking about, and we took issue with the last couple sentences of it. When it becomes 456 Yankee, that is moved to being now number 9. The lines in question were in fact removed, but a new number 8 is inserted, and the new number 8 is what I said we missed. We didn't see that. because it had not been part of the prior version. So, but you can sort of see by comparing the two that what happened was it got kicked down to 9. A new number 8 was put in, but number 9 does in fact remove the line at issue in the old number 8. If that wasn't confusing.
Not at all.
Okay.
And what I was asking you is that in 456, that line in 456 Yankee, is that number 8, the line that appeared in the final version?
It did.
Okay.
And again, I'm not sure how we missed it. I think because I'm thinking, and again, I can't speak for my client. I can only speak for me, that we were still going off the last thing we had seen. Honestly, I know this final version got emailed to me. I'd be interested to know, just to be sure, what time the plea happened versus this email, because that would make sense as to if I didn't see this last version email before we ended up taking the plea. And again, I'm not saying it did happen. I'm just saying I'm trying in my mind to figure out how we missed that. How did that happen?
And as you were asked on cross-examination about your understanding and your client's understanding or initialing of each of these acknowledgements, was there any acknowledgement other than 3 or 8 that you ever felt you needed to explain?
I don't think this particular question's been asked before.
That you ever felt you needed to express to the state, my client may need to explain these further?
I know that I expressed to the state that at some point my client.
Your Honor, I'm sorry. I'm going to object because I believe that answer calls for something that invades the province of the attorney-client confidential relationship.
Not when he expresses it to the state.
Overruled.
Go ahead.
Was she indicated?
I believe, because at some point it was stated to the state that explanation may be necessary.
Okay.
I don't recall whether we itemized exactly which items were going. I think it was a general statement that, hey, we're signing it, we're agreeing to it, but some of this may require explanation. And at the proper time and place, i.e. if he's called to testify, he's going to want to be able to explain the answer.
Okay.
So I think that generally, without going into any detailed conversations with my client, but that's generally what I recall we were communicating with the state to say, we're sign us up, we're initialing, we're going forward. But some of these things, because there are a couple things in here, may require further explanation. And when asked, they'll have a chance to explain.
Were any of those things inclusive of any other acknowledgement or understanding besides the 2 that you already pointed out?
Could
If you need,
I
here it is.
have the final initialed?
I think you,
I think your question is going to that. I just want to.
do you have 1AS in front of you?
455.
1AS, what's that?
No, this is 455Y. I think at some point.
These are the exact same.
Okay. reviewing this, 3 and 8 would be the only ones that I believe he would have, I'll strike that. 3 and 8 were the ones that there seemed to be issues that may require explanation.
Okay.
Just 3 and 8.
Did you were asked on cross-examination whether at any point the state asked to sit down with your client. Did you perceive the November 20th, the November 2022, the November 30th, 2022 email from the state as a request to sit down with you and your client?
Well, it was a proffer offer. So yes, that would essentially be your communication to see about having a sit down with my client. And I think I indicated I received it, but we did not respond until middle of December.
Okay. And that response, did it include any agreement to sit down with the state?
No, it actually was simply saying, why don't we talk about a resolution?
Okay. And as it relates to the questions on cross-examination about the November 27th email and the November 28th emails and where you were when you were able to review them with your client.
You mean December 27th?
Did I say November? Yes, I did
Okay.
mean, thank you. The December 27th and 28th correspondence. At that time, were you and your client aware that you all were not the only people who had yet to resolve your cases?
Correct.
Well, the question, having known me personally for as long as you've testified you have, did you feel that comfortable enough?
Hang on. Relevance as to what he felt?
Yes.
What are you, finish your question so I can.
Because the question,
What was the other one? I'm sorry. Do you,
I don't have any.
rephrase?
All right, I'll rephrase. Did you were asked on cross-examination about receiving communication and plea offers, plea agreements on December 27th and 28th and meeting with your client at the jail and in court? Do you
Okay.
recall those questions?
Yes.
At the time that that was going on, did you believe or did your client indicate to you to express to the state that you needed maybe any additional time to go over those agreements?
No, at that time, we were very eager to ink a deal and resolve the case. And ultimately, that's how the 27th happened in the evening, as well as once we show up to the courthouse, how on the 28th, we were trying to iron out an agreement, which we ultimately tendered to the court.
Were you or your client through you ever given the impression or led to believe that if you did not ink a deal on December 28th, it would go away?
No, I don't think there was ever a sense that we were given a deadline. It was, hey, now or never. I think it was just a matter of he's expressed. He had different concerns and different motivations. So again, not speaking for him, but he seemed very eager to ink a deal if a deal could be had on the 28th.
Okay. And you were also asked about your desire or willingness to go to trial. If your client chose to go to trial rather than ink a deal, regardless of the financial arrangements that you had made, would you have continued to represent him?
I hate to say I could not have afforded to stay on the case and to go to trial, because a trial of this length would have bankrupted me.
Okay.
I mean, there's starve me. I don't know what's the word, but ain't no money being made when you're in a courtroom. And if you're not getting paid for being in the courtroom, there just ain't no money.
Understood. Without getting into what you told your client, would you have made efforts to arrange for him to have suitable or to? Okay, I'll withdraw.
Right.
Did you ever move to withdraw in this case?
No. Again, that's something that would have come later, depending on the choices my client made.
Okay.
And because his choice was to get this plea done and to execute it, that never became a ripe kind of consideration.
You were asked on cross-examination a number of times about your client's sentence. I'm going to show you what I've marked as states 463, and a copy of which has been, not as it's labeled, but the certified has been provided in discovery. If there's anyone that wants to see it, I'm just giving the copy to the witness.
Okay.
463 Yankee. You were asked on cross-examination whether count 30 was held open until the end of this initial trial. Do you remember that?
Something to that effect, yes.
And do you have any memory of it being necessary for your client to be sentenced on count 30 as a result of the way that that particular count had to be filed with the clerk of court?
Actually, we put creative language in there where if he sees his cooperation through, we could actually be in a position to withdraw his plea on that count, and then it would be null pros. So one of the benefits is count 30 will go away, and then he'll just be on probation for the primary count. So that was, I guess, one of the incentives in this agreement was, I guess you now have both ends. The incentive that that count could go away, or the deterrence that, hey, there's a hefty sentence if you go afoul.
And does 463 accurately reflect your client's final sentence that he was given that day, in addition to or under the restrictions of 18S, the plea agreement?
It does.
Okay. And so would you please tell the jury what your client was actually sentenced to on that day?
No, I'm going to object. That's actually been asked and answered previously.
Well, I haven't seen the document to see what it says, but it seems to me, at least the implication is, no, it hasn't. So I don't know. Do I need to see the document?
I can show it to the court. Now, passing to the court, 463 Yankee, I ask the court to pay attention to the sound. I'm gonna walk around. You're welcome.
Okay. No, I don't overrule.
Thank you, Judge. Would you please tell the jury what your client's ultimate sentence was.
Ultimately, the sentence that I'm looking at now indicates 15 years to serve on probation to count one,
Yes.
and then 15 years to serve on probation to count 30, consecutive to count one.
Okay.
Which would be 30 years of probation. And once this, going to the third page, which is the continuation,
Please do.
that if the special conditions outlined in this sentence are satisfied, and I won't list them, but there's a few of them, but ultimately, he would be allowed to withdraw his plea as to count 30, and count 30 would be non pros. That's a Latin way of saying dismiss. So that he would only be standing on his sentence for count one.
Okay.
And I know someone had, since I'm here, had asked me about whether there was a curfew, and I do see where there's a curfew as part of this sentence.
Thank you. Wrapping up with the last three questions, you said that you were asked on cross-examination, you testified about whether or not your client initially was charged with the murder of Donovan Thomas and whether the police dismissed those charges. Do you remember that?
I remember
The question.
the topic, coming up,
Okay.
question coming up, yes.
And do you know whether it was the police or the district attorney's office that declined to charge your client?
Yeah, I can't say I've known police to ever have that authority or make those decisions. It was my understanding it was the Fulton County DA's office who made the decision not to pursue those charges any further.
Okay. And the last question is, you spoke earlier about representing your client in his 2015 case
Okay.
and entering that plea in his best interest under Alford. Do you recall that?
Yes.
And at the time that you represented your client on 22 SC 183.
I'm sorry, just turn your microphone on.
Yeah, we can't really hear you. Sorry.
I'm sorry. I'm going to object and we can approach if
All right.
I'm sorry, that is getting too complicated to.
All right, so Ms. Love, my recollection is that the issue of the 17 plea, having been an Alfred plea, came up during your direct of, I don't feel like it was this witness. I feel like it was Mr. Sledge.
Because it was initially what happened is that
Your Honor, it's my memory that it did come up with this witness.
Also,
Yes, it was
Okay.
asked.
okay. It originally came up with Mr. Sledge on your direct because you started reading the factual basis.
that's what I was about to say.
Okay,
So what I was about to say was initially it came up with Mr. Sledge
Yeah.
because of
okay,
my,
we all remember why, but then how did it come up with this witness?
on cross-examination, the question was asked, if, I think something along the lines of, it, and it may have been by Mr. Adams, what is an Alfred plea? Do you do that because you feel it's in the best interest
Right.
of your client? And does that consist of certain things?
Okay,
And so because Mr. Adams got into the questioning of what, what's an Alfred plea? What does it consist of? Why do you do it? And then there was, I believe, according to my notes, there was questions or there was testimony about Mr. Sledge's mother being ill
Right.
and him expressing stress over that.
right.
My notes then,
Okay. I mean, I remember now. Thank you for recalling it to my recollection. So what is it that you want to ask?
at any time did he request that this plea be made simply in his client's best interest?
Okay.
Did his client ever request of the state to enter this plea in his best interest?
Okay.
And given that, of course, since now everybody knows that his client knows what an Alfred plea is, it's important that this plea and these statements weren't given or made simply because they were in his best interest.
Okay.
Understanding his testimony today, that wasn't something that was ever conveyed.
Okay. Well, those two questions, did he at any time request it and did his client request it? Seem like they would be appropriate. I don't know if you intended on some kind of third question or if that was just your argument, but did you intend a third question after those two?
No, my last question was intended to be, was this plea made under offered? Or was this plea, did your client ask us to allow him to make this plea under offer? So
Okay,
it's two
so we
questions.
know it wasn't under offered.
Right.
So did he at any
Well-
time request that the plea be a best interest / Alfred plea, and did his client ever
We-
ask?
We know, the jury doesn't know. That's why I was saying that. And I believe that it's,
Well, yeah, they do, because I instructed them already that for the one, they could not consider anything, and for this one, they could if they found inconsistent statements.
Okay.
So, yes, so Mr. Short, so as to those two questions,
I am not going to pretend that I was in the middle of their plea negotiations.
hold that closer.
I am not going to pretend I was in the middle of their plea negotiations, but I feel that many of us know that the only individual that was allowed to plead guilty under Alford is Mr. Sergio Kitchens, who had zero evidence against him, quite frankly. And so I don't think anyone would have perceived that as an option to even ask.
Okay, well, that's not an evidentiary objection.
Well, I would object to those questions being asked, because I believe any discussions that he would have had with his client about Alford invades the province of the attorney-client relationship. Can he be asked whether or not the plea was entered under Alford? Sure, that's how the plea was entered. But whether or not he had any discussions or whether his client asked him to approach the DA's office in regards to an Alford plea, I believe invades the province.
All right, if you were to make that objection, that would be sustained, but that objection would not be valid with regard to whether at any time Mr. Wright requested that the plea be permitted as a best interest plea. So you can ask that question.
Thank you. And Your Honor, as Mr. Wright has already testified that if his client asks for something from the state, he's obligated to convey it to the state. I don't believe that asking him whether.
All right, well, that's already before the jury, so.
Okay, thank you.
Okay, let's get Mr. Wright back in, and hopefully the jury will be ready to come on back in too. I wonder, I don't know whether he heard that or not. Can somebody see whether the jury's ready? No, I know that, the jury. Mr. Wright's on his way. Yeah, okay. Is the jury ready? Great, they seem to be. Thank you. Go ahead, Ms. Love.
Thank you, Judge. Just two more questions. You were on cross-examination. Did you testify that you were not certain that your client would have to testify
It was
on December 28, 2022?
correct. That the point was, if you need him and you want him to testify, he will. But it wasn't set in stone. It was going to be a game time decision once you made the decision.
And was your client served with a subpoena by the state on December 28, 2022 to testify in the trial of this case?
I don't know if he was served a subpoena that day. I mean, we were served a subpoena recently, and we've never taken issue with service or the fact that he will appear whenever the state wants him to appear. So we've never made issue of service.
And finally, you were asked on cross-examination about an Alford plea, and it revolving around somebody saying they're not guilty. Was this one of those pleas?
This plea, no.
Thank you. That's all that I had.
All right, thank you. Is there any recross from any of the defense attorneys?
I Mr. Stillwell.
No recourse on behalf of Mr. Williams.
All right, thank you very much. Mr. Wright, thank you for your time.
Thank you, Judge.
And remember, your client is excused but not released, so if he comes back, we'll see you again, but otherwise.
Understood. Thank you, Judge.
All right, call your next witness.
Yes, Your Honor. The state calls Mr. Thomas Burnett to the stand.
Thank you.
Does firm testimony about the truth, whole truth, nothing but the truth?
I do.
Absolutely.
State, spell your first and last name, of course, please.
Thomas Burnett. Oh, THOMAS BURNETTE.
Good afternoon, Mr. Burnett. How are you doing?
Hey, how are you?
Mr. Burnett, did you drive or fly here today?
Fly.
You're from another state?
Charlotte.
And what do you currently do for a living?
I'm a service consultant at an Infiniti dealership in Charlotte.
And what was the first year that you began working for Infiniti?
1997.
What did you do when you first began working for Infiniti in 1997?
I was a valet. I was a valet while I was going through college.
And in that capacity, would you drive Infiniti cars?
Yes.
After that, where did you end up? Did you ever end up getting a degree?
Yes.
Where did you get your degree?
DeVry University.
And what was your degree in?
Business administration.
Did you get that here in the state of Georgia?
Yes.
Now, after when you first were working as a valet, what was the next job that you had after getting your degree?
With Infiniti or just the next job period?
Next job period.
I was in furniture sales.
What did you do after that?
I went back to Infiniti.
What drew you back to Infiniti? How did you end up back working for them?
Just a familiarity. I had a relationship.
Now, when you went to Infiniti this time, what was your job position?
Currently what I do, a service consultant.
Now, can you explain for the jury what is a service consultant? What all do you do?
I meet with the clients or customers that come in for maintenance or repairs on their vehicle. I assess what the vehicle needs, whether it's check engine light on or a leak or no starting issue. I basically get the information from the client and put that in a manner so where the technicians can properly diagnose the vehicle. Once it's diagnosed, I reach out to the client and let them know what repairs are needed and gain the authorization to fix the car, and then basically handle the client throughout the process on updating them, let them know when the car is ready, payment, etc.
Now, as a service consultant, with what all you just described in terms of your job, what all you do in that job, do you have to have familiarity with the makes and models of Infiniti?
Yes.
Can you explain for the jury how you gain familiarity with Infiniti makes and models as a service consultant?
Well, we have to do certification tests quarterly to make sure we're certified. And then, also just being around the vehicles, you learn and pick up certain common things about the cars. And you have to identify certain things with them to know what year it is, what kind of type of oil it takes. When you're quoting prices, you quote them accurately. So.
Now, as a service consultant, is your primary focus, is it true or false that you're focused on the clients that come in?
Mainly, yes. Yeah.
Now, to be an effective service consultant, with Infiniti, do you have to understand the technician side of the business?
Yes, because I have to basically interpret as far as what the client is saying, as far as sometimes help the technician understand what the issue is. And then there's a lot of terms and expressions that technicians will explain to what's wrong with the car. And sometimes that's not always not customer friendly for us to understand what actually the issue. So sometimes I have to do some interpretation as far as making it a little easier to understand on what actually is going on with the vehicle.
Now, Mr. Burnett, jumping back to after you got your degree and you worked in, when you first went back to Infinity, what location were you working out of?
South Atlanta, Infinity of South Atlanta.
Is that the one on 4201 Jonesboro Road?
Correct.
Now, how long did you, what year was it that you?
2005.
And how long did you work at that location?
Till 2020, 2021, I'm sorry.
So roughly about 15 years?
Yes.
Now, over those 15 years, how often would you drive Infinity cars in any capacity?
Every day.
Would you drive them in both daylight and nighttime?
Yes, I've also owned, I currently own Infinity, and I've also owned Infinities from like 2007 on. So.
Do you get some perks working for Infinity in terms of owning an Infinity or buying one?
Yeah, we do get some discounts or considerations as far as whether.
Now, what kind of vehicle do you currently drive?
Q50, Infinity Q50, a 2020 Infinity Q50.
Now, since you've been working for Infinity, when did the Infinity Q50 first come on the market?
2014.
Now, when it first came on the market, what type of, how would you describe an Infinity Q50?
It's a sports sedan built on performance. It was pretty unique in design as far as at the time, as far as it had distinct features as far as the headlights, tail lights, the front grille were pretty distinctive at the time when it first came out.
Now, is there any Infinity model or make that is similar back in 2014 when the Q50s first came on the market?
No, there was a G37 sedan, but it looked completely different than the Q50. It wasn't really. There's a whole different design. So
now, is there any significance to the G37 in terms of the name of that car versus the Q50?
No.
In terms of the lettering or numbering?
Oh, well, like as far as the G37 was basically named after the engine size. So the 37 is how Infinity used to distinguish what size engine was in the car. When the Q50 came out, it was the beginning of the rebadging to where all the same models that basically had the same. So a Q50 is the sedan, the four-door sedan. A Q60 would be the two-door car, and then they identify the engine size by the decal that's on the side of the car, whether it's a 2.0 engine or 3.0 or 3.7 back when it first came out in 14.
Now, you have described a decal on the side of the Infinity Q50. Is that unique to that make and model?
Pretty unique. You don't see it a lot on other makes. Most makes don't identify what engine size is in the car by any type of badging on the side.
So previously, Infinity, you would know the engine size based on
the name.
Yeah. And then after that, they put a visual indication of the engine size?
Correct. Yeah, they were kind of tired of changing names every time a new engine came out. So it went from like G35 to G37, and then it stopped, and then they just changed the badge on all the cars to Q.
That makes sense. Now, are all the makes and models in the Infinity fleet start with Q?
Correct. Yeah, the cars are Q, and then the SUVs are QX.
Now, you were working for Infinity in 2014 when the Q50 first came out.
Yes.
Has the Infinity Q50, does it have a sunroof?
Yes, pretty much probably 80% of the models, or maybe even higher, have a sunroof. The only ones that don't have a sunroof are the Q50As, and that's on the back of the car. You'll see the A, and that was kind of like the base entry level car, which we didn't sell very many of those cars because dealerships wouldn't order them because they knew they wouldn't sell them. So
now, when you said when you went back in 2005, you worked till 2020. What did you do after leaving the South Atlanta Infinity in 2020?
I moved to a few dealerships around. Initially, I took a job as a service manager at a Nissan store in LaGrange, Georgia. That didn't quite work out, so I worked at the Nissan in Morrow. Then I went back to Infinity, different location. I was at the Cobb County location, Nally. And then I worked for Lexus for a short period of time before the Infinity South Atlanta store asked me to come back. And that was in last year.
So you kind of went full circle back to that South Atlanta
did.
Infinity?
Yes.
How did that come about?
I was up there getting an oil change on my car, and the manager that was kind of like the consultant there at the time, he was just working part-time, he was retired. Him and the current manager asked if I was interested in coming back. I had still a lot of clients that would come through the store asking for me and stuff. So they asked if I had any interest in coming back, and it lined up with what I needed at the time, so I went back.
Now, what do you like about working for Infinity over these years?
I like taking care of customers. Also like the product.
Sustain, hang on just a second. If you hear somebody say objection, will you just pause for a minute while I deal with that? Sustain.
Now, yes, Your Honor. Mr. Burnett, I'm going to show you what's been marked as State's Exhibit 459 Yankee and 459 Yankee Alpha. And again, defense counsel, please.
Yeah, I mean, I searched for the other exhibits from the same.
Sure.
Your Honor, hand in the witness both 459 Yankee and 459 Yankee Alpha. Mr. Burnett, what are 459 Yankee and 459 Yankee Alpha?
Both pictures of a Infiniti Q50.
How are you able to recognize them?
The shape of the vehicle, the headlights are pretty distinctive. The front grille and the tail lights are also pretty distinctive. And it also says Q50 on the back of the picture there as well too.
And for your testimony to the jury, would using 459 Yankee and 459 Yankee Alpha aid you in describing a Q50 for the jury? Aid your testimony?
Do you mean that he's helped with this?
Yes.
Yes.
Your Honor, at this time, the state is tendering 459 Yankee and 459 Yankee Alpha for demonstrative purposes.
All right, those are admitted as demonstratives.
Publishing State's Exhibit 459 Yankee. Now, Mr. Burnett, earlier when you were describing a Q50, what is the most significant physical aspects of this make and model?
You mean like what makes it stand out the most?
Correct.
I'd probably say the headlights on the front grille.
Now, currently, so you've also had an Infiniti Q50, you said since 2020?
Correct.
How has, since it came on the market in 2014 to present day, has the shape or the vehicle itself change much?
Not much at all.
Overruled.
Now, Mr. Burnett, does your Infiniti Q50 2020 how does the front emblem look? Is it any different in terms of lighting?
There's some options on the newer versions of it, like 16 and up, where it lights up at night when the headlights are on.
Was that a feature when it first came on the market in 2014?
No.
Do you know when that lighting first came into the Infiniti fleet?
In 2016, when they changed the engine sizes in the car. It went from a 3.7 to either a 2.0 or a 3.0.
Now, is in 459 Yankee, are the rims on the tires, is that standard, not standard? How would you describe those?
Those are standard wheels on it. There's two options. There's the 19s and the 18s. And some have, it's three. So 17s, 18s, and 19s. Looking at it, those appear to be the 18-inch wheels that are on.
Now, Mr. Burnett, earlier you'd mentioned about when Infiniti got away from naming the cars off the engine size, that they had a decal. Is that correct?
Correct.
Can you show the jury, if you see it, is that decal visible in 459 Yankee?
Yes. If you go just slightly back from the front wheel, you can see a silver kind of spot or kind of there. That's actually the decal that's on it.
Mr. Burnett, I'm gonna move this mouse. You tell me if I'm getting closer.
Keep going.
Okay. Same direction?
Yeah. You're right there at it now.
That is the decal that indicates the engine size?
That's correct.
Now, turning to 459 Yankee Alpha, can you describe for the jury what stands out to you in terms of it is different about the Infiniti Q50 compared to other Infiniti makes and models?
Just the shape of the tail lights are a little different than some of the other models are. They kind of mirror the headlights where they're kind of a little more kind of sunken into the body of the car.
And what do you all have certain naming conventions for the colors that the cars may come in?
Yes. This particular color is diamond graphite.
Now, when did you leave what was your last job in the state of Georgia before you left?
I was service consultant at South Atlanta, the Jonesboro location.
And when you moved to North Carolina, did you work with an Infiniti company there?
Same role, yes. Just in Charlotte, yes.
Now, back in March of 2016, what location were you working in for Infiniti?
Union City, the 4201 Jonesboro Road, Infiniti of South Atlanta.
Now, do you recall a time where any law enforcement personnel ever came by that location when you were working to interact with you?
Vaguely. There was, and I don't remember the exact date or time, but there were some officers that came in. They were directed towards me. At the time, I was like the assistant manager or lane manager, sometimes we'll call it. And I think one of my other employees pointed in my direction. They had some photos or like a poster board of a car. And they just kind of asked some questions about what type of car it was. And there may have been a few other questions. I don't recall what they were. And then they were like, hey, this is part of an investigation. We'll probably be in contact at some point.
Assisting.
Now, Mr. Burnett, do you have any independent memory of what kind of car the vehicle was that they showed you in those photographs?
Not in 2016. No.
Okay. Now, I want to publish, Your Honor, what's already been admitted as 296 Yankee And the state's gonna start the publishing at 8 minutes and 30 seconds.
All right.
Mr. Burnett, while that's getting set up,
Oh, yeah, sorry.
in
Didn't know you-
preparation for your testimony, have you?
Hang on just a
Sorry,
second.
Your Honor.
I don't see anybody waiting.
Have you more recently than 2016 reviewed some surveillance video and photographs for your trial testimony?
Yes.
Your Honor, publishing State's Exhibit 296 Yankee at 8 minutes and 29 seconds.
All right.
Ms. Burnett, if you can, just watch this screen.
Okay.
Pausing. Now, Mr. Burnett was, I know that clip was quick. I'm going to publish 292 Yankee Hotel, which is already admitted. Now, is that surveillance video clip that you just watched, have you reviewed that before testifying in court here today?
Yes.
And what vehicle was depicted in 292 Yankee between 8 minutes and 30 seconds and 8 minutes and 40 seconds?
It was Infinity Q50.
Now, I'm going to briefly on the screen, what's going to be published is 292 Yankee Hotel. Let me know when you can see that. Is this a still frame from the surveillance video that we just watched a moment ago?
It's, no. Yes, it looks the same.
Now, can you describe for the jury what stood out to you about being able to identify this as an Infinity Q50?
The headlights, the way they appear, you also can see the black grille, and it's kind of hard on this one, but as it gets closer, you can see like a little bit of the logo, like the silver reflecting in the front grille area.
And when you mean when it gets closer, you mean when
As it starts to come, I guess, closer to where it, before it goes off the screen.
Publishing, Your Honor, what's already been admitted as 292 Yankee Indigo. Now, Mr. Burnett, is this also a, I know it's currently blocked, but still framed from the surveillance video that we just watched?
Yeah, that still seems to be the same car, the Q50.
Now, what I'm going to do, Mr. Burnett, is I'm going to replay 292 Yankee at 8:30. You tell me when to stop when you had mentioned the silver emblem, right, as the car gets closer, in your words. So I'm going to play 292 Yankee, start at 8 minutes and 30 seconds, and you just tell me when to stop when you think it would be helpful to see that.
Sorry, it's
all
real
right.
quick.
It's all right. I'm gonna publish 292 Yankee Juliet, which already been admitted as 292 Yankee Juliet.
You can almost see the reflection of it right in that screen there.
And when you had described, and by the reflection of it, do you mean, what do you mean by that?
It's almost like where I guess the lights or the street lights or whatever are reflecting off of it.
And
you can kind of, like if you look in between the headlights, you can see there's something there. It's not black like the rest of the grill is.
And you mean the front part of that Infiniti Q50?
Yeah, the logo that's in the front of it.
And when you had mentioned is this almost basically when you said as the vehicle gets closer, as it's driving off screen, when you reviewed this surveillance video, is at what point from where the car currently is to when it's off screen did you notice that?
Originally, right, well, when you originally played it the very first time we spoke about it, I noticed it pretty quickly. Honestly, the very first time I looked at it, I was just looking at the car. I didn't even see what was going on the side. And then the second time you read me back, I saw all the other stuff that was going on with it. So, I mean, as you recall, when I first saw it, I was like, well, that's a Q50. And you were like, how do you know that's a Q50? And we kind of went through the same. I was like, headlights to the grill and same thing. And then also the tail lights, you can kind of see as it's taking off.
Now, thank you, Mr. Burnett. Now, since March of 2016, when law enforcement came and spoke to you, to present day today, do you have any other knowledge or information or any information about this case that this surveillance video is involved with?
No.
Mr. Burnett, I'm also going to publish 292 Yankee starting at 10 minutes and 40 seconds through 10 minutes and 47 seconds. It's gonna, it's close. Yeah. Mr. Burnett, that surveillance video that we saw, have you seen that angle before?
Today I saw it.
Okay. In preparation for
Right.
testifying. And in that, what car do you see in 296 Yankee between 10 minutes and 40 seconds until when we paused it at 10 minutes and 48 seconds?
It's the same car from before, it's just a different angle, it looks like. We're seeing more of the back end of it.
Earlier, you had mentioned the quarterly training that you've gotten since working in Infiniti. Can you describe what that entails for the jury?
So anytime there's any new models or any new features or anything that's been added to the cars, they will have to go through certification tests on them. It could be modular, so where we have to do like interactive videos and answer questions at the end, or it could just be an article that we have to review and then go back and answer questions. It just depends. Usually on a brand new model, it's more interactive stuff because they want make sure that you're following along and know what's going on. You don't just skip straight to the test. But sometimes on some of the refresher stuff, like if it's just a specification change, like the engine size or new wheel package or something, it'll just be like some articles that we just read and then answer the questions based off of that.
One brief moment, Your Honor. Mr. Burnett, when the Infiniti Q50 came out on the market, when was the first time that you drove it? Did you ever drive a 2014 Infiniti Q50?
Yes, it was, besides customers coming in, we also had them as loaner cars. So that was one of our main cars we used as loaner vehicles. So we were constantly pulling them up, getting customers in and out of their stuff. Yes, I've driven them a lot of times.
And what aspect of the Infiniti Q50 made you choose to buy it in 2020?
The size, the performance of it. It's a pretty fast vehicle. It has a lot of power. And from my standpoint, it's also pretty reliable because, again, I see what goes wrong and with them. So that's what kind of drew me to it.
Now, the dealerships or the locations you've worked at for Infiniti, have those all been classified as dealerships?
Yes.
And is your customer either primarily or exclusively people buying a car for themselves? Brief indulgence, Your Honor.
All right.
In terms of, do you have any familiarity with Infiniti vehicles being sold to rental car companies?
So they would buy directly from, so they buy Hertz Enterprise, they buy directly from the manufacturer. Now we do see them when they come in for recalls and that sort of stuff. So they do bring or if there's warranty repairs that need to be done on them, Hertz Enterprise, they do bring cars to us for us to service. So, but like far as purchasing wise, they buy them directly from the manufacturer.
And Mr. Burnett, what is your favorite physical attribute of the 2014 Q50?
I'm gonna object that's too relevant.
Sustained.
I would too, Your Honor. That's why with that said, Your Honor, the state does not have any more questions for Mr. Burnett. Thank you,
All
sir.
right, thank you. Are there any defense questions for this witness?
Yeah, sure. Yes.
Thank you.
Good afternoon, sir.
Hey, how are you?
I'm good. I am fabulous. Fantastic. One of the last things you said was that the rental companies, I think Hertz, you mentioned, sometimes brought their cars in to be serviced at the locations you work at, correct?
Correct, because we're close by the airport, so we would get a lot of their cars brought in. So,
do you have any personal interaction with any car, any Q50 that would have been brought into your dealership back in January or February of 2015?
I wouldn't be able to recollect that.
And you would not have been the one to observe or look at or inspect any vehicles brought in from Hertz anyway, would you?
Only thing I would do was check it in, which basically would mean getting the mileage, VIN plate off of it, and doing like a walk around on it for damage. That would be my end as far as inspecting it.
Okay. But in 2015, was it 2015 or 16 when the Atlanta police came to talk to you about Infinitis?
I don't actually remember the exact date.
You have no real memory, no clear memory of when that was, right?
No, not the date, no.
Okay. Is it fair to say that when they came to see you, though, they didn't bring an actual vehicle with them for you to look at or offer your opinion on, right?
No, they were like photos.
They were photos.
Yeah.
The images that you just saw, right, and I'm going to ask the state's indulgence in a bit to put some of those back up again. You would agree with me, though, that those photos. All right, how about that?
We're good.
Those are black and white images, right?
What's that? The photos they brought in, or?
Yeah, well, No, the photos that you were just looking at, and the video you just looked at, still shot, and then the two videos, one of the car rolling forward from the front, the other one from the back.
Well, the photos here are color, the ones that they,
Can I step up?
Yeah.
Alright. Right, so these, and I'm gonna reference for purpose of the record, 459 and 459A. These are the photographs that were presented to you from the state a little while ago, right?
correct.
Right. Now, that's not what I'm talking about, though. I'm talking about the video that you were looking at, that the state played. Would you agree that was a black and white video?
I don't know if I would classify it as black and white. It wasn't the greatest of quality of video, but I would say it was black and white.
Okay, let's go do it again. Tonight, would you be kind enough, please, to put up what the state has marked as 292 YI, Yankee Indigo, I guess. All right. Can you see what's on the screen in front of you, Mr. Burnett?
Yes,
Now, you read 292 YI, that's the image that you looked at before, correct?
yes.
You're not able to tell what the color of that vehicle is, are you?
I can tell it's a grayish color. I mean, just like the color, the car that's behind the white one appears to be like a reddish color.
Okay, so let's see, are you gonna tell me that that vehicle that you said is in Infinity is a, what did you say it was a diamond graphite color vehicle?
Could I say it from the picture? No, I mean, from this, no, I couldn't say it was diamond graphite, but I could say it's grayish in shade though.
Okay. You said that you recognize this as an Infinity because of your familiarity with Infinities, correct?
Correct.
Now, to be clear, you're not a scientific expert, right?
No,
You've never been qualified as an expert in Infinities or identification of vehicles, true?
no scientist, no.
Okay. You've never been qualified in a court of law as an expert in identification of vehicles.
Never been to court before or anything for it, but as far as an expert in knowing infinities, I probably would say, yes, I know all the models.
Okay. Tell me whether or not that vehicle that you're looking at, the one that you've identified as an Infinity Q50, has standard size wheels or non-standard wheels on it as you described earlier.
And we're talking about the screen, not the pictures, right?
Oh, on the screen, yes.
I could, you can barely see the wheels from this.
All right. Looking at that image that the state showed you that's on the screen right now, tell me where you see on that there is an Infinity emblem or insignia on the front grille.
This one doesn't capture it. They tried to roll it forward to where you could see that there is something silver in it, but technically they couldn't stop it at the right time.
You said technically, you don't see it at all, do you?
Not in this frame, no.
And in fact, when you were describing the image you said earlier, or you saw earlier, you said that you can quote almost see it. Understand that?
Correct.
All right. Looking at this vehicle on the screen, are you able to tell whether or not there's any damage to the front bumper or fender of that vehicle, as though it's been some sort of accident of some sort?
Not on the screen, no.
Are you able to see anyone, if there's anyone hanging out of the sunroof?
Not from this angle, no.
I'm curious, do you know whether or not the 2014 Infinity Q50s have, I'm gonna use OnStar. I don't know if there's another name for a tracking.
It's Infinity Connect, yes.
That's a tracking system.
Correct.
Do you know whether all of the Infinity Q50s had tracking software in it that would allow you to track the car and tell you where the car is at a given time?
They have the capability, but there's a subscription that has to be paid for it to be able to do it. So if the subscription isn't paid, then it's not active for us where you could track it at the time.
Okay. You testified earlier, and I'm still referencing the images up on the screen, right? You testified earlier about there being an emblem on the side of the Infiniti Q50 that's a little bit behind the front wheel. Right, you remember that testimony?
Yeah, but that was off of the picture though.
Right. So put the picture aside for right now and just looking at the image that was shown to you by the state. And this is the same image that was shown to you back in 2015, right?
No, they just had pictures. They had like pictures that came back in then. There was no videos or anything then.
Okay. So APD came to see you in 2015, they didn't show you this video?
No.
So look at the video that you're seeing right now, that you've identified. Look at that car. Point out to me where that emblem on the side of the vehicle is that tells us it's an Infiniti.
You can't see it from this angle. Not on the video.
So I just want to make sure I'm clear, and I understand your testimony correctly. 2015, APD comes to you and they show you some still shots of a vehicle.
Correct.
And they ask you to tell them whether or not it's an Infiniti or not.
They asked basically to identify what kind of vehicle it was.
And just so I'm clear, were the still shots that they showed you, still shots from this video?
I honestly don't know where the pictures, I mean, that was 15, 16 when they came. I honestly don't know where they got the pictures from.
And they never told you, right?
No, they basically said that there may be some further questions they may ask and they'd be in contact, and that was that.
Was that the only time that they came to ask you anything about any Infinitis?
Yes, I didn't hear anything about it again until was it April or May, I think they reached out. I guess they still have my number on file from when initially I did the interview, and they called and asked if I remembered it. And I honestly didn't remember a whole lot of it at the time. As we talked further into it, some of it started to come back, but I didn't remember what kind of car was involved or any of that until I actually saw the video that they played for me.
When you say they called you, were you talking about the DA's office or?
Yes.
You didn't talk to anyone from the DA's office back in 2015, maybe?
No, I would assume it was just a local police. They were in uniform, so.
Police officer?
Yes.
First time that you've seen that video, and when I say that video, I'm going to refer to 292YJ. I think that's the one that you said you saw from just the back view of the vehicle.
Yes, the store or whatever. It looked like a store or something from what I could see.
Ms. Knight, would you be kind enough, please, to put up 292YJ for me? Yes. It is a video. Actually, no, it's not. I'm sorry. Let me correct that. That's 296Y at times 10, 840, 847. Let me correct that for the record. That's exhibit 292 Yankee Delta. I think. Did you see the image that, it went across the screen there, Mr. Burnett?
Yes.
And it's kind of what I one more time, please. Well, wait, let me ask you a question.
Sure.
Would I be correct, if I were to say that back in 2015, no one ever took you to an actual first location to look at any affinities?
No.
And we'll almost be able to image Mr. Burnett? Mr. Burnett, I want you to pay attention to the, yes, between 840 and 847, okay?
Okay.
See that car driving past?
Yep.
That is the car that you took a look at today. It was the first day you saw this video, right?
This one, yes.
And then your testimony is that based on that, vehicle passing by in the video, between 840 and 847, you can recognize that as an Infiniti Q50, as an Infiniti Q50, all right?
Correct, yes.
And then it was written below that even in that image, as it went by, you didn't see any Infiniti emblem on the side of it.
No.
You didn't see an Infiniti emblem on the back of it, right?
No.
You didn't see anything that looked like damage to either the front or the fender or of the vehicle, right?
No.
You see anybody hang on to the sunroof or window, right?
No.
So lights on the car.
Yes.
And you saw that it was a car.
Yes.
Thanks, sir. That's all.
Any other defense attorneys have questions for this witness? All right, is there any redirect?
Yes, Your Honor.
Go ahead.
Ms. Burnett, when law enforcement came to meet you, did they ask you if it was a Infiniti or ask you if it was what car it was that you were looking at?
They just asked me to identify the car, the vehicle.
And since you and I have spoken or met, have you always lived in the state?
Yes.
And previously, were we able to speak or Zoom with one another? Is the first day you met in person, you flew in today?
Correct.
Ms. Burnett, I'm gonna try, so to slow this video down. So the state's going to publish 292 Yankee Alpha. It's gonna go at a slower pace, and if you see, Mr. Burnett, where you want to freeze it, and you can spot the emblem in the front grille, just let me know.
Okay.
So, Your Honor, for the purposes of the record, we're starting at 8 minutes and 32 seconds
Okay.
on 292 Yankee Alpha. Mr. Burnett, did that help any slowing it down, Mr. Burnett?
Not really.
That's fair. That's fair. Now, some of the questions, do you remember being on cross-examination, you were asked questions about, can you see the decal or can you tell about the tires? Do you recall that?
Yeah, what questions you just asked? Yes.
Yeah. And with this surveillance video that you've seen, is it that they don't exist or you're unable to give an answer on those questions because of the surveillance video?
They
Objection
exist, I'm
calls
just
for
not able-
speculation.
Overruled.
You may answer, Mr. Burnett.
Okay. Of course, the wheels and those things exist on it, and you know it's a Q50, so it's kind of hard to. Being that I know the vehicle, it's kind of hard to know. Okay, that's a Q50, and I know where everything is on it at. But trying to necessarily make it fit into the video where I can say stop right here, I see it. It's kind of a little hard to do in real time. And for the court's time, I don't know if we got this time to start to just dissecting and stopping it every 2 seconds to see if you can get to there. But again, I've seen the pictures. I drive a Q50, so I know what actually is on the vehicle and where it's located at. But as far as trying to using this quality of video, as far as to stop it, is kind of hard to do.
Thank you, Mr. Burnett. The state has no further questions for Mr. Burnett.
All right, Mr. Adams.
They may have a couple more questions for you, sir.
Oh, sorry.
They're almost done, but not quite.
So, Ms. Bennett,
Yes, sir.
so even though in the still shots and the videos that we've seen, right, you don't see the identifying item that you mentioned. You don't see the decal, right?
Not in the video, no.
You don't see the emblem on the Infinity emblem on the front.
Not in the video, no.
We can't identify whether it's standard size wheels or whatever kind of wheel that you referenced before, right?
Not in the video, no, sir.
So even though we can't see any of the things that you say would identify something as an Infinity, your testimony is that you know that it's an Infinity. Q50.
Right. So this is not the same car. Like
You tell me, is that the same car?
it looks like the same car in the video. It's a Q50.
Yeah.
You may.
So you're thinking that 459 and 459A, which has been given to you by the state, you believe that this is the same car that's been shown in that video?
The video is definitely a Q50, yes.
Okay, you think it's this car?
It appears, as far as the color and everything else appears to be, but
does this?
Again, these are all standard things. It's not like this is it has custom wheels on it or if it has a custom grill. Those are all the standard things that's on the car. So every Infinity has the grill. Has the logo on the grill. Every Infinity has a badging on the side. Those are the standard headlights. Those are the standard tail lights.
Right.
So if it's a Q50, then it has those things. So
every Infinity has that emblem on the grill that we can't see on the video, right?
Q50, yes.
Every Q50 has that emblem on the side that we can't see on the video, right?
Correct.
Every Infinity has maybe standard, maybe not standard wheels that we can't see on the video, right?
Correct.
But your testimony to this jury is that these pictures given to you by the state, the same vehicle that's on that video.
Correct.
All right, that's all.
All right, now you're free to go.
All right, thank you.
All right, and it's just about 5 o'clock, so I think we'll break for the day. And I'm going to remind y'all, sometimes I give you a longer reminder, that you need to decide this case based only on the evidence that's admitted inside this courtroom. So please don't use the internet or any other source, electronic or otherwise, to get any kind of information about this case or about concepts in the law. Don't read, watch, listen to any accounts of this trial that might appear online, in print, on television, on the radio, or otherwise, including social media. Don't discuss the case with anybody or allow anybody to discuss it with you or around you, including don't discuss amongst yourselves. Leave your notepads, notes in the jury room. And remember, for y'all tomorrow, it's a non-jury day. We'll be working, but we'll see y'all back Thursday morning at 9. Thank you. Okay, Ms. Love, you had wanted to, I guess, tender for admission 452, 453, and 460. Why?
So, Judge, they were all referenced, and by conditionally admit, what I was asking for permission to do, since they had all been identified by a witness as a particular thing and true and accurate reflections of them. And because they had been referenced so much during the testimony, my request was to tender or admit rather for as evidence 444Y, since 1AS.
You didn't even mention 444Y.
I didn't mention all of them that I wanted to. I started, but then when the court seemed inclined not to entertain that.
Deal with it right then? Yeah,
right.
Since I didn't know what you were really talking about in terms of conditional admission. Okay.
Right.
So 444Y is
Yes.
one of them.
So the state tenders 444Y conditionally upon any redactions that we either agree on or the court simply instructs have to be made. 450Y, 451Y, just 452, 453, 454, and 456Y, as well as 460Y. And we have not tendered 463, which is the certified, which was used to refresh Mr. Wright's recollection. We're just adding that to the record because it was a document that had been referred to. So for conditional admission, we were tendering 454, 450. I'm sorry, 444Y, 450Y, 451Y, 452Y, 453Y, 454Y, 455Y, 456Y, and 460Y, to the extent that those reflect the emails from Mr. Wright to the state. So there
And then what about 463Y?
That was just the last.
Right, are you tendering that one?
No, I have it in my hand. I was about to hand it to Ms. Winfrey because it is a document that needs to go as part of the record, as something that was used to refresh the recollection. I had it, and while I had it, I just referred to it. It's not being tendered.
Okay.
It's just certified of Mr. Sledge's conviction.
Okay, and tell me what you mean by conditionally admit. Do you mean potentially redacted in some way?
Yes, yes, I
Okay.
do.
All right. And are there objections to the admission of any of these in any form
All of them,
whatsoever?
all of them.
Okay. Yeah.
Now, if the point is they were referenced in testimony and therefore for the purposes of the record, not to be
Well, I wouldn't consider that admitted.
right.
I
But
mean, I assume every exhibit that is utilized, whether tendered and admitted, tendered and excluded, or just used with a witness, is going to be a part of the record. Is that y'all's understanding as well?
yes,
Okay. So, in terms of admitting them,
so, okay. The emails,
I'm sorry, Mr. Shaw.
yes.
450 was admitted, that was not.
Yes, 450 was, you're right.
the emails, we had lengthy discussions about the emails and about the objections and about the problems with some of the things that were discussed in the objections. Ms. Love indicated that she wanted to talk about number 3, which seemed pertinent and wanted to get the wording exactly right. I had no problem with it. The other defense counsel didn't seem to have a problem with it. So we read exactly what the wording is. There's no need to admit that. And there's still problems with the other email, the other factual acknowledgments that are discussed in that email regarding the prior versions of the agreement. I went through great lengths to preview what I was going to ask so as not to open up any doors for quote unquote statements that were never uttered or adopted by the witness to be admitted into evidence. The state is now asking the court to just admit documents into evidence that have those statements on it. Those statements provide nothing to the jurors. I don't know what conditionally means. I'm never going to agree to admitting things subject to redactions when I don't know what those redactions are. And it's completely unnecessary. We have read from the documents to get the words correct regarding specific things from those documents, specific acknowledgments from those documents. And both sides have done that. And that's what the testimony is. The proposed documentary evidence is full of inadmissible hearsay and other things, and also provides nothing to the jury at this point. So on behalf of Mr. Stillwell, I should say, oppose the admission of any of those documents into evidence at this time.
On behalf of Mr. Williams, I'm going to join in Mr. Short's response. We've already objected to the admission of any of those documents. And we would, I also do not know what a conditional admission evidence is, so I'm not opposed.
Right. So I guess she means she wants to, if possible, be able to come to agreement about redactions of them. And if not, then present them to the court with her proposed redactions, which, I mean, maybe y'all can get together, and since we have a non-jury day tomorrow, we can deal with that tomorrow. But I don't mean y'all figure out what the potential redactions are tomorrow. I mean, have something ready to present.
Yes, and so, Your Honor, in as much as the tendering was done today, I'll withdraw that request until I have a redacted version to show counsel for defendants into the court.
Okay.
And the conditional, the court had it exactly right. It was until there was either an agreement or something that the court
Or then you
deemed-
can present it to me and I'll make a decision.
Yes.
Okay. All right. Well, then have those ready first thing in the morning.
We will, along with the other additional emails that the court told me to have.
Right, for me, for an in-camera inspection. And then I would like for us tomorrow, I know that a couple of people have forwarded some things for our task list for tomorrow. There's a motion in limine filed by Mr. Ryan about autopsy photos. There is a motion in limine by Mr. Williams that provides some law and argument on an issue that we had raised our last non-jury week, but not decided about. I can't remember whose statements they were, but some of the wiretap statements we'd kind of gotten partway through and gotten, I think it's fair to say, probably bogged down on one particular call and whether there's hearsay within hearsay and whether it qualifies under 801 D2E. So we'll circle back on that issue and maybe make our way a little bit more through that. And then I would like for us to at least start on what's everybody's understanding of which exhibits have been admitted and which haven't, kind of what the status is of the exhibits so far. I covered everything that anybody's forwarded. Is there anything else? There might be.
I haven't yet seen, but I know that they probably are in my inbox. So we'll, since we should be, I guess, ready to respond to the motions in limine, if they're new.
Well, the one of them I think is new about the autopsy photos. The other one's kind of just a follow up on some of them. Yes, sir.
And we filed a brief on that yesterday, I believe. So I just want to make
maybe
sure that
that's what I'm thinking of. Is the Williams motion limine separate than the Mr. Nichols brief
Yes.
on that?
Yes.
Two separate issues
Yes.
or the same issue?
I did not repeat what the Honorable Mr.
But
Nichols
is it
lawyer
the same
said.
topic?
Yes.
Okay,
I just added
All right.
other law.
all right. All right. And honestly, that'll probably carry us through the day. We probably won't even get through all of it. But any other topics or items we need to be thinking about?
Could the court just inquire who's the next several witnesses? It got kind of,
Sure.
I know it's a witness issue, I was told.
Yeah. So Thursday and Friday, who do y'all anticipate your witnesses being?
Second, let me get a list. Officer Adrian Pitts. Miss Sharon Latners. Potentially crime scene tech Turner, Mr. Denise Bell, Officer Sean Hill.
Turner Bell and who?
Hill,
Hill?
Officer Sean Hill.
Okay. All right.
Crime scene tech Jenkins, Detective Thorpe.
Okay. That we won't get through all of those in 2 days. So that'll give y'all the list of the next several. All right.
And the one main one, if we, the one has.
It's just the gremlins that are apparently in residence here in 1C.
Ready for us to go.
We had intended to.
That one doesn't seem to be working at all. We may need to put new batteries in some of these.
If another witness that we had.
On our list is available, that we had mentioned last week, that we had approached the bench about regarding a condition that they had. a lay witness.
I can't remember. Do they know who you're talking about? I can't remember. Do y'all know who you were?
Your Honor, I'm going to withdraw that. We'll leave it at where we have it right now.
Okay.
I'll speak to anybody who asks about
Okay.
that, but we're.
Mr. Weinstein, you seem to want to say something.
Normally it's that I have to use the restroom, but actually it's on a different subject
All
matter.
right.
Just briefly, I'm not going to be here, Your Honor, tomorrow. Ms. Singerty is.
Okay.
But I guess I'm going to go back to the old saw that I keep bringing up, Your Honor. And just briefly, just give me 1 minute.
Okay.
1 minute. I'm going to renew my motion for the court to limit the state's time. I'm going to cite your authority under 244403, 246611, and I'm just going to ask you, please read, if you haven't already, U.S. v. Reeves.
I've read it.
I think it's very persuasive on your ability and the logic and reasoning behind putting a time limit on the state. We just got through with a witness, Your Honor, that the state said was going to take 3 hours. And we spent, now that was just 3 hours on direct. And we just spent a week on that witness, Your Honor.
Well,
So
we had 2 witnesses this week.
5 days, and then, yes, Your Honor, I'm not going to disagree
Well,
with you.
wait, no, this is only, what
When
is
it
today?
was-
This is only
It was
Tuesday.
Tuesday, I think it was Tuesday, Wednesday, Thursday, Friday, and then Monday, but whatever. It was far, far longer than 3 hours. So please look at Reeves again and consider it, Your Honor.
So I am reticent to say, for this witness, you can only have X amount of time.
No, I'm asking for.
However, okay, we've got a, how many count indictment here? With at least 8, in addition to the RICO count, 8 different sets of crimes. And the case law also provides that the state is entitled to, and it is, a violation to prevent them from being able to present their case. And I know that's not what you're asking, but how am I to know how long it is going to take them to efficiently present the amount of evidence to cover all of the things that are in this indictment? That being said, I will say that not so much, honestly, even the amount of time that was taken up with Mr. Sledge, because I assume the 3-hour estimate was thinking Mr. Sledge was going to be a cooperative witness, and Mr. Sledge didn't ultimately end up being so much of a cooperative witness. But y'all, I mean, the amount of time that was taken up by everybody with Mr. Wright was probably a bit excessive. And I put everybody who asked questions almost in that category. I do think that the state needs to, get more targeted and focused with the examinations. And then there seems to be redirects take almost as long as the directs, and that should not usually be the case. And nobody ought to be rehashing things that have already been established, either at, a little bit of leeway every once in a while to, okay, let me refamiliarize you to this as I lead into what I want to get to. But like a 5-question, there's this, there's that, there's the other that everybody's already heard. And I'm addressing this to everybody who might need to hear it. That we don't need. And we just don't need to be rehashing everything. And we also need to think redirect is supposed to only cover things that are in cross, and recross is only supposed to cover things that were in redirect. So please get more focused, and to the extent that people make the 403 waste of time objection, I'm going to take it seriously.
Well, I think Reeves addresses, I guess, a lot of that and the need for us to raise 403 by eliminating that and eliminating the courts, or reducing, according to the judge in that case, eliminating the need for the court to spend a lot of time on 403s, because it forces the state to be more efficient in their presentation of the case. And to say that the state is moving with any degree of efficiency or I just don't know what to say about the plotting rate that the state plows through the direct examination. And I don't see anything. I mean, we're 100 witnesses in. We've got 100 witnesses to go. I know that's a rough number.
I'm hoping we don't actually have 100 witnesses to
Well,
go.
that seems
I
to be
really
a
would
bottom.
like that to be narrowed down. But I don't think we've gotten to the point yet where we can turn to that topic. But I mean, I've said a couple of times that the state needs to take a very close and careful look at the witness list that still exists and do everything you can to make sure that we're not being cumulative with our witnesses. And I hear you saying maybe we should be doing the same thing about a time limit. And y'all, I mean, I know it's not a trial, but incredibly important issues get decided in appellate courts all the time. You get, 20 minutes to talk about something that could be groundbreakingly different. So, I'm not saying that at some point I might not just say, all right, you've got 5 hours for this witness's direct and you can do it in that amount of time. I'll need to know more about what you need to cover with that witness, but it's not outside the realm of possibility. I do think that given how long Mr. Copeland was on the stand, that we've made real progress in that we've now been able to finish 2 witnesses in far less time than that. But I hope 3 witnesses in far less time than that. So I feel like it is progress, but we could probably get more targeted than we are.
Okay.
So I can, in as much as this, I'm probably the most verbose of us all, but I can make my questions tighter.
Okay.
The intent on redirect has always been to respond to things that I hear brought up on cross, and to the extent that I can be more precise in pointing out the specific question that was raised on cross that I'm trying now to have the witness explain further or give an explanation for, I will do that as well.
All right. And I do not want to call anybody out in front of the jury. I'll say I don't want to excuse the jury constantly. That takes a lot of time just for them to even file in there and file back. So, I'm telling y'all this now in the strong hope that what you're saying you're going to do, you're actually going to do. But if I see that it still is as, I don't know the right words, but depending upon what I see, I may have to deal with it further.
Okay, thank you. And I wouldn't keep raising this if my client wasn't stuck at Rice Street. So that's the reason I bring this up every once in a
Well,
while.
I mean, I think it's fair to bring up
Thank you.
regardless.
Thank you, Honor. I appreciate you hearing me
Okay.
out.
And I also, just for the record, and so that the victims that are named in our cases are aware, we are appreciative of the courts affording the state the opportunity to effectively present to the jury all the evidence that we have in this case without being cumulative and without being redundant. But our victims obviously deserve every bit of attention that we have to offer to this. And I appreciate the court's willingness to afford that to the state.
Okay. All right, if there's nothing else, then let's convene at 9 tomorrow.
Thank you, Judge.